Good evening, everyone, and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. My name is Charles Smith, and I'm the chairman of the board. This board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, are Judy Freshman to my immediate left, Enta Malice to my immediate right, Paul Melnick to my far right, and Peter Owen to my far left. Also present is the professional staff, including Stephen Rissy, to my extreme far left, the coordinator for the Board of Zoning Appeals and the secretary, and assistant to the zoning administrator, Blake Bowen, in the first row there. Let's see here, we have Mark Hamela sitting at the computer, and Jaquay McNeil, our planning technician, who is at my extreme far right. She is the person to whom you give your speaker slips. We thank you for being here, and I want to extend a warm welcome to everyone. Now, to avoid disruptions, we ask that you please put your cell phone in silent mode or turn it off. On the front table, you will find staff reports for each of the cases which are before us this evening. There's one staff report. So if you have not had a chance to review it, I encourage you to come up, take a look at it, and then place it back on the table so that any others who may have an interest in seeing it can do so. Now, the board's powers are prescribed by law in the Code of Virginia and are set out in further detail in the county zoning ordinance, which is adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance or, of course, change the state law. That authority rests with the county board and, of course, the General Assembly. This board does have the authority to do 3 things, and those are: we can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there's no option in the zoning ordinance to allow such modifications. We can grant variances from specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that we deem necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning-related policies of the county. Now, to do this, the Board of Zoning Appeals shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria: that the strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, or alleviate a hardship by granting a reasonable modification to a property or improvements that requested on behalf of a person with a disability. Now, the property for which the variance is being requested must have been acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, and that the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance. And that the granting of the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and or subdivision ordinance. Now, when deciding appeals of the zoning administrator, this board must use its judgment to determine if the administrator was correct. Now, this evening, cases will be called, and a brief staff report will be given, and a recommendation will be given. Now, following Following that, board members will ask any questions of the staff which we might have. And then next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. Now, if you choose to make a comment, please come forward to the podium so that your comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip which is available on the end of this table, on the end of the dais, and provide that before the item is called. Now, the board, after we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit, and we won't condone, cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for appellants in appeals cases, and 5 minutes for applicants for use permits and variances. In all cases, speakers representing organizations shall have 3 minutes and individuals 2 minutes. After the board has gathered all the information we need and discussed the case, we'll decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from a decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the remainder of this session or leave at your convenience. Again, thank you all for being here, and I'm going to ask the staff, Mr. Rissy, to please call our first case.
Case number V-11449-19-VA-1 is a variance request by Jarrett and Lori Tubman, the owners, to permit a maximum lot coverage of 51.7% instead of 48% as required for a one-family dwelling with qualifying front porch and rear detached garage in the R6 zoning district regarding the replacement of an existing deck in the R6 zoning district premise known as 1719 North Monroe Street. Staff recommends that the board adopt the attached proposed resolution denying the variance. A proposed alternative resolution has been provided should the board see fit to approve the variance as advertised.
Thank you very much. Any questions of Mr. Rissy?
Mr. Chairman.
Mr. Owen.
I have a number of questions about that mostly relate to the driveway. Do we have a breakdown of the square footage on the parcel that's is specifically related to the driveway and is specifically related to the deck? The applicant provides some helpful pie charts and so forth, but I couldn't easily find the underlying specific numbers.
So I don't have anything other than the material that the applicant submitted, both the pie charts as well as the lot coverage sheet that is towards the back of the package.
And does the lot coverage sheet typically break down by improvement?
Yes.
Oh, it does.
Yes.
So can you help me perhaps find that information on that sheet? I see main building in total, but I don't see outbuilding, deck.
So it has main building on the front, and then on the rear it has the driveways and parking pads as 1,294 square feet, stoops and landings, including those associated with stairs, being 42 square feet, getting them the subtotal of 3,460 square feet that is used to calculate the lot coverage.
Thank you. I still don't see it in the packet, but that's what I needed. If we approve this variance at 51.7% coverage, is the variance approval in any sense for the deck, or is it for the site as a whole?
It is for the site as a whole to have the 51.7% coverage. It's specifically instigated in this case by the applicant's desire to rebuild the existing deck, but it does cover all of the elements on the site.
For the site as a whole, shouldn't our deliberations consider all of the contributions to coverage, including the driveway? And so, for example, even if we didn't think the deck was, not having the deck was or wasn't unreasonable or wasn't driven by a hardship, if we thought the driveway or the garage or the main building footprint were driven by those factors, that would equally be a rationale for approving a variance, right?
I imagine you could use any of the elements in your rationale. I would, again, though, say that this is spurred by the applicant's desire to rebuild the deck, so that's what we're analyzing.
I guess that's what I'm taking issue with, right? It's what is it spurred by? If it's not approving variance for coverage for the deck, but it's approving a total cap for all improvements for all time that may be built on the parcel, the driveway comes and goes, the garage comes and goes, the main building is redesigned and rebuilt, like lots of things could happen, and it sounds like what we're being asked to do, and have happened, and what we're being asked to do is to say, at the end of the day, these people can have 51.7% coverage on this, taking into consideration all the things that are going on the property.
Yes, but the applicants are specifically asking to rebuild the deck. If they were asking to rebuild the driveway, we would do the analysis based on that. But in this case, they're asking to rebuild the deck on the non-conforming lot with everything on there.
So if we vote to approve this variance and then later they rip up the driveway and rebuild it, would they have to come back for another variance?
Yes.
They would, even if they don't exceed 51.7% coverage.
Yes. The variance is specific to both the structure that they are asking for relief for as well as the property. So they also couldn't tear down the house because, again, in this application, they have presented these structures.
Yeah.
If they wanted to change the structures, they would have to come back and ask for a new variance, even if the amount was the same for new structures.
So even if they want to tear down and replace the deck again, they'd have to come back for another variance?
Yes.
So even the very same deck that we've approved, they only get one iteration.
Well, okay. If they were to rebuild exactly what you had approved, the exact same structure, that would we would be okay with.
And
If
so
they were to make changes in any direction, additional height, additional dimension, changing the layout, that would require coming back.
Okay, so likewise, if they rip up but exactly replace the driveway in exactly the configuration it's currently in, they would not need another variance?
No, they would need another variance for that because that has not been approved by the Board of Zoning Appeals. Just like the deck. They have an existing deck.
Yep.
And they have the 51.7% coverage that they are asking for tonight. But since it is non-conforming and has not been approved by the Board of Zoning Appeals, they need to come to the Board of Zoning Appeals to ask for the variance to rebuild a non-conforming structure. So since the driveway is not proposed to be replaced in this application, if they were to come back in 6 months and say they wanted to completely tear it out and rebuild it, we would say that was not covered by what you took to the BZA in this month, and we would make them get a new variance.
And, okay. So, okay, got that. I got that answer. It's a little bit surprising to me, so I'm rolling with it. And so then my question is, would it be outside the scope of the advertisement for us to give a broader, more permanent zoning approval? So I'm looking in the resolution, for example, right, the proposed resolution for approval.
Mm-hmm.
And if we were to approve it, I don't think it mentions the deck in the resolution.
I think the only place the deck is mentioned is in regarding the replacement of an existing deck section, which is part of the advertisement, but I do not know to be part of the proposed alternative resolution.
So, right, all right, and that gets to the core of what my first question was, right, is what you're saying is that what's advertised is 51.7 as it relates to reconstruction of this particular deck, but not 51.7, period, full stop, not related to any particular improvement. And do you think it would require re-advertisement if we were going to entertain just approving a blanket 51.7% coverage for whatever improvements may come and go on the site?
Don't they have to be related to something?
Yeah, I think that would need additional advertisement because I would feel uneasy saying that this property just blanket gets 51.7% and then can switch out and swap structures as they see fit within that. I do not think that would be covered under this advertisement.
All right. I think I'll pause for now. I may have more, but I think I get the point.
Thank you very much, Mr. Owen. Ms. Malice.
The staff report indicates that there have not been letters of support. Are there any letters of support that you received since this?
I have nothing new since your application has been printed and distributed, but I will let the applicant speak to that.
Any other questions of staff? If not, Mr. Melnick.
So I was, the concept that a non-conforming structure can be repaired and maintained, I was looking at the ordinance, and I believe it's the ordinance that says maintenance permitted, and it says non-conforming buildings or structures may be maintained except as otherwise provided in section 16.2. Is that, but I don't see, it just says repair, it says maintain, but it doesn't say repair. You know, does staff construe maintain and repair to be synonymous?
Yes, we have a pretty tight definition of what we consider to be maintenance and repair, and we have a line that says if you are doing replacement of structural members, it is more than a maintenance or repair. It is the replacement of structure, which isn't permitted. So by maintenance and repair, we allow for the replacement of non-structural members and for the addition or strengthening of structural supports, but not the replacement of structural supports. It's very confusing, and we get that question a lot.
Okay. Thank you.
Does that answer it for you?
So just so I understand, so you can't replace, like even if you're maintaining, you can't replace a structural part of it, but say like a warped board on a deck.
So like the decking can be replaced because it's not structural. It's the same thing if you think about a wall. You can change out the window, but you can't take down the structure of the wall and build up a new one in a non-conforming location.
I gotcha. Okay, thank you.
Welcome, Lori and Jarrett Taubman. You've had an opportunity to review the report. The report describes your interaction with staff, so we'd be happy to hear any statement that you want to make in behalf of your application.
Thank you very much. Good evening. We appreciate the opportunity to present to you tonight. As you know, we're requesting a variance of the total lot coverage limit, otherwise would apply to our home. This is to allow us to replace our deck with one of the same size and shape. It would be entirely within the footprint of our existing deck. And this is, as we detail in our application, over time, there's been some deterioration in the deck that is inhibiting our ability to use it. And some of this deterioration relates to structural elements, which is why we're not just, repairing or seeking to maintain in accordance with the zoning ordinance. Our home, including the deck, was constructed in 2004 prior to the amendment of the zoning ordinance that lowered the applicable lot coverage limit to 48%. So while our existing deck is grandfathered, replacement deck would not be. As reflected in our supplemental statement, we believe that grant of the requested variance is appropriate because it would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance. Compared to other lots in our area, ours is narrow and deep and irregularly shaped. We have a large tree in our front yard, which limits our ability to use the yard for parking. These unique characteristics resulted in the placement of a detached garage in the back corner of our lot and the construction of a long driveway to that garage. These features together cover roughly 25% of our lot, 20% for the driveway, about 5% for the garage, i.e. more than our house and much more than our deck. But the 48% lot coverage limit, it does not account for our special circumstances, and it does not provide us with the same degree of flexibility enjoyed by other homes in our area. If we did not need our driveway to facilitate use of our garage, we could replace or even expand our deck without any need for a variance. In contrast, a grant of the requested variance would relieve us from this hardship and would provide us with the flexibility enjoyed by other similarly situated homes in our neighborhood. Accordingly, under the variance standard set forth in the code, we think grant of the variance is appropriate. We want to note that, with due respect, we've reviewed the staff report, and we just want to note that it really doesn't acknowledge or account for these factors that are set forth in our supplemental statement. In particular, there's really no analysis regarding the unique characteristics of our property that we identify, including the tree in our front yard, the fact that we have this long driveway and it accounts for the majority of the coverage between the garage and the driveway, and that it imposes this limitation on our ability to use the property given these unique characteristics. At the same time, we think, unfortunately, the properties that the staff report suggests are comparable to ours are, fairly distinguishable. They're, the ones that are supposedly narrower and smaller, they don't have, some of them don't have garages, or they incorporate only a relatively small driveway in the front yard. There's also, two of the three that are identified are corner properties that, are just fundamentally different than ours. With respect to the notice point that was raised earlier, we do want to note that we did significant outreach to the properties that are adjacent to ours. And while we did not get letters from them specifically supporting us, we had long conversations with a number of the property owners and residents, explained to them what we were doing. We gave them sort of multiple opportunities to raise concerns if they had them. We gave them a copy of the statement that we submitted with our application. The only reason, honestly, that we did not request letters in support is because when we first spoke to them about this, we did not view our application as being controversial, and then later did not, feel like we wanted to impose on them by going back and taking more of their time. But, those that we did speak to understood what we're doing, didn't have any concerns, and, in most cases supported us. I should also note that in a few cases, we were not able to speak to the owner of the property because they were not also the residents of the relevant property in those cases. And in one case where we couldn't touch base with somebody, we mailed through certified mail copies of the package that we had left, including a cover letter, the statement describing what we were doing that we submitted to the board for its consideration. So we think everyone has fair notice here. The last point I wanted to note, which relevant to our application, is that the staff report also doesn't really address the unreasonable restriction point. I think the wrong standards being applied there as well. I'm happy to talk about that if there are questions. Thank you.
Thank you, Mr. Talman. Any questions of Mr. Talman? Any questions, any? It's on you, Mr. Owen.
So I wanted to pick up on, you discussed in your statement as well as in your written statement the large size of the driveway and how that's a bigger contributor to coverage than the deck is. And I'm wondering, did you consider as part of this discussion reducing the size of your driveway?
So I'm not sure exactly how we would do that. If you see the size of our driveway, it's extremely narrow. It's really only large enough for a single car to drive down it. And I should note that even if we were to sort of eliminate a portion of the driveway, the fact that a portion of our property isn't paved does not mean that it would not qualify as a driveway. If we needed to drive over that portion of our property in order to reach our garage, for instance, it would still qualify as a driveway under the...
Really glad that you made the point just that way, because it opens up the question I had for staff next, which is, as the applicants have just pointed out, the ordinance is explicit that driveways count whether paved or unpaved. How do you measure coverage for an unpaved driveway? How do you determine the square feet of an unpaved driveway that is a driveway only because of the way it's used to drive cars over it?
Two-track.
We would need to see the area used for driveway purposes indicated on a plat, just like any other surfaced driveway, whether it be asphalt here, gravel, grass pavers, whatever you want it to be. It just needs to be indicated on a plat so that we can measure the square footage.
I see. So the people who have driveways that are just two strips of concrete at tire width apart, you would not count the area to the outside of those?
Not to the outside, but to the area inside.
Okay. So it strikes me that your driveway is quite a bit wider than the area that is between the wheels of a car. And that's the smallest width a driveway can be in Arlington, according to the staff's answer. So it strikes me that it's conceivable, not necessarily practical, but at least possible, that you could use your driveway the same way that you use it now to travel from the front to the back of your property without having it be as wide as the current amount of paving is. It sounds to me, based on the fact that we're having this conversation, that you had not considered narrowing your driveway.
So, I mean, I think it's fair to say we thought about it at a high level, but I am not at all sure that even narrowing the driveway would have given us, sort of 308 or whatever square feet of headroom that we would have needed.
Right. You need to reduce the driveway width by about a quarter of its current width in order to get the 307 square, I think it's about 307 square feet that your deck is. Is that right?
That's right. Yeah, we would have needed to bring down the total lot coverage to 48%. Right now, it's 51.7.
So anyway, it seems in the ballpark potentially that your driveway is actually wider than the minimum distance the ordinance demands a driveway to be in the configuration it is. So I'll just note that. But I don't want to go too much further since it's not something anybody has considered. In other circumstances, I would have wanted to ask these questions in advance so everyone could be prepared to give answers, but we can't do that with variances right now. So I'll just leave it at that. All right, I think I'll take a pause on that.
Ms. Malice?
I think we're aware that we just recently denied applications exactly like this. Sorry? Yeah. So we're in a tough spot here to find a reason that we shouldn't deny yours.
If I could speak to that. I'm aware of the application that was considered last month. My wife was at the hearing and heard it. I think that it can be distinguished in a few respects. One is that the variance that was sought in that case was not of the total lot coverage limit. It was of the main dwelling limit. So the driveway and garage, which are not part of the main dwelling, really wasn't an issue in that case. The other point I raised, which is related, is that there was no showing in that case that the sort of extraneous features were larger than they otherwise needed to be due to the shape of the property, or we also, as we noted in our application, have this large tree that really restricts our ability to use other portions of our property for the purpose. And finally, I would just note that we're asking for a variance ahead of time, not after the fact.
Sure. Nevertheless, the standard that we use is economic hardship, not inconvenience to you, but actual economic hardship, and that's what gives us difficulty here in working our way through this. Exactly.
One thing I note, and I don't know if this gets to the point you're trying to make, but our house was built in 2004, 1 year before the lot coverage limit changed, and so I think in that last case, it sounded like there was a large remodel occurring of a home that had been there for a while. And in terms of thinking about kind of zoning policy and this idea of lots coming to conformity through time, when you think about properties kind of overturning through time and such, a longer period of time than since 15 years might be something that you're thinking of. When we bought this house, we didn't buy it thinking that we might have to remodel it even though it's only 15 years old, because the doors are going to empty to nowhere on 2 levels because of a potential zoning issue. So I think that that's another kind of issue, that this is a relatively new home. It's not a home where we're going in and anticipating doing major remodeling, and so when you're thinking about hardship there, I think it's, might be a little bit different than last week's.
Well, I don't know how much latitude you have to explore doing something with your driveway or doing something else. you know, it's, you're making an argument because you have a garage, you required this long driveway. If you had no garage, then you would not have this driveway issue at all. You're basing your argument on the garage, basically, the existence of the garage. So I don't know how much, is it in the realm of possibility that other modifications could be made that would bring you into conformance? And I don't have the calculations in front of me to even see what we'd have to do to a driveway, and if it's even feasible. That would be something I would like to explore, but I don't know if staff has already looked at that and knows that that's not a realistic option.
Staff hasn't run calculations on that.
I mean, if I could just address that point, I mean, the garage existed on our property in 2005 when the zoning ordinance changed. So if you look at the standard that's set forth in the Code of Virginia that's on this point, the question is whether this imposes a hardship with respect to the property and the improvements thereupon that existed as of the date that the ordinance was changed. The garage was there, so we shouldn't be required to knock down our garage or otherwise change our garage in order to avoid the hardship. We're seeking what I think we view as an extremely reasonable accommodation to put us into a position that is similar to that of similarly situated properties, in our area that just aren't burdened in the same way that we are.
I understand your argument. I understand what you're saying, but your use of hardship is different from what the law defines as hardship. Again, not an inconvenience, but actually an economic hardship that essentially makes your property unusable, or in value, has no value.
Could I just on that point sure, sorry.
So I'm looking at my colleagues. I don't know where you all are in terms of whether you think this is worth pursuing further, or whether you all have
Mr. Tubman, you can reply to that.
I just wanted to note that I'm aware that historically there's been a standard that's been applied, which essentially is that you're only entitled to a variance if the property is effectively unusable. But the legislature specifically changed that standard in 2015 and replaced it with an unreasonable burdens standard or unreasonable restriction standard. And the basis of any reasonability or reasonableness test is that you have to look at both sides and both factors, and you try to balance them. So it's not, is there any possible use of the property? It's, in light of all of these factors which we've set forth, is there an unreasonable, burden that's being placed on us as a result of the strict application of the ordinance? I think we've made the case that burden exists. I would note again that there's no contrary analysis or finding in the staff report. If there had been, we would be able to speak to it, but we're not given that opportunity here. So,
Mr. Chair.
Mr. Melnick.
Okay, so I do have a question to staff. So one of the items in the statement of justification on page 1 is that there's a vertical post supporting the upper level that is partially sitting on top of a horizontal decking board. What it seems to say is that's not the correct construction, and it would seem like a vertical post, is a structural member of it. But the staff, because it would seem like this is a new enough structure, would think that as a part of the inspection process that they would have, the inspector would have looked at the deck, and if there was something unsafe, like a board, a supporting structure where it shouldn't be, like in an unsafe position. But do you know offhand, whether this somehow passed and it's unsafe or wrong construction, and what do you have to say about that?
I will say I absolutely am unqualified to determine whether any part of this deck is structurally unsound or up to current codes. But I will say there is a provision in the zoning ordinance which does say that replacements that are required by code are allowed. It's in Chapter 16. And so if there was something that they needed to do because code dictated that what they had is currently unsafe, that is an allowance provided by the zoning ordinance. But I am not going to be the one to make that determination.
Okay, well, that's very helpful. So what I have to say is, I do think this has great similarities to the case we had really at our last meeting. And in that case, it was actually, the argument was that it was an accident, that it was, they rebuilt it and didn't know that it needed a permit. And here you are, it's the same, you haven't replaced it. So we aren't dealing with that issue. And that was one of the persuasive things before about unreasonableness, in addition to some other things. But here we don't have that argument, this sort of, just replacement, inadvertence, that kind of thing. But so my point is, it just seems to me what's being listed here as to what's being done, deck boards, those aren't structural. The deck railings, I'm not, an expert on this, but I don't think that'd be structural.
No, railings are not structural.
And then you're saying that the supporting member, if that's unsafe or not up to code or done wrong for some reason, that could actually be done. So it just seems to me that all this could be done, just as a matter of right, really. So I'm not for it, just because it just seems like this could be done outside the variance process. Just repair and maintenance.
So on that point, I mean, what the points that we mentioned in our statement of justification were meant to be exemplary. They were not meant to be exhaustive. So, if we were to go through and catalog all the issues, there would be a number of those that would be structural in nature. We just called out sort of the most obvious ones that were, sort of exemplary and were motivating our decision. I mean, believe me and believe us that if we could avoid this and feel safe, using our deck with sort of minimal repairs of the type that you're talking about, we would do that. I think we would be thrilled if we could replace the deck and not require a variance or make the sort of changes that you're talking about and really address all the issues without the need for a variance. But my fear is that if we were sort of compelled or required to take that route, we would be back here in a few months, because I just don't think it's feasible after having spoken to our contractor.
Yeah, we actually consulted several contractors in the process of figuring out what to do and what made sense. So actually the vertical post that we mentioned, that was something that a couple of contractors saw, but there's obviously variation in quality. And the recommendation that we were given was, they're going to replace more, and so given the presence of that issue, it just, in my mind, makes me wonder about other potential issues, and so that's kind of why we were aiming toward kind of the full replacement.
Mr. Chair?
Mr. Chairman, I'm the chairman. Mr. Melnick just pointed out, I think, something that you should explore. That is that if the deck is not constructed according to code, then it can be repaired and made to conform to code without the necessity of a variance.
May I just specify that section of the ordinance is really meant for selective replacement of structural members of a building or structure that are nearly an imminent state of collapse. It's not meant for kind of an elective pre-replacement program. It really is meant that if you have a wall that's about to fall down, you can replace that wall so the building doesn't fall down. It's not meant for regular replacement of things that may fail at some point.
Well, if an engineer said this and cited the building code and said this particular post is not built for this deck according to code, that would be enough. It seems like to me to insulate them from any harm that might come down the road, because now they're relying on a professional who's licensed to provide just that kind of information. Now, whether it's going to collapse today or in 3 years really is kind of an unknowable.
I would say that it really isn't meant for that type of replacement. Buildings are built according to the code. that is in place at the time when they are built, and codes are constantly updated. Much of Arlington is not built to current codes because it was built under an older code at an earlier time. If that was your logic, by that reasoning, you could replace most of Arlington with new structures that meet current code. This is really meant for structures that are in danger of collapsing, falling down, hurting life.
Well, it sounds like this is a structure that's a deck that, if used, could fall down. So it's rendered useless by virtue of the supports not being appropriate, if that's the case.
Don't know that it's quite that.
Yeah, I
I thought I heard that in your.
what I would say right now is we're not, we have not had an engineer come out and assess, in formal. To address a point that was made earlier about whether or not the approach that is being recommended would result in economic hardship, I think at the point where, in order to pursue this, we need to start hiring like professional engineers and getting into legal fights. That potentially dwarfs the already significant costs that we're encouraging by doing this project. I would note that I think the best evidence that you have that there's sort of good cause for what we're doing is the fact that we're basically replacing an existing deck with one of the same size and shape, and we're incurring significant costs to do so. If we could avoid that and feel comfortable using our deck, we would.
Mr. Chairman? Are we finished with the hearing?
I was going to entertain anything more Mr. Taubman might have had by way of argument, and then assess. Do you have any questions, or?
I have some areas I want to explore, but not until the hearing is over.
Okay.
Mr. Chair?
Not as a part of the hearing.
Right.
Okay, so my purpose, of even bringing all that up was just to try to help you all find a way, just because the overarching idea that I have that was even mentioned at the last hearing is that there is a policy of the county board that, the idea is that after a while, non-conforming things are just going to go away because you can't replace structural things. And so, even though this is not, ancient, that is a policy. And so, what my hope is that looking at what was wrong with it, it just seems like you have so many outs here without this variance, because I'm not inclined to vote for it. Just because I don't see a hardship, I don't see you're unreasonably restricted from using the property. So, it just seemed to me that was a good out, what I was mentioning about repair and maintenance and the code, bringing it to code if you have to, if there's a danger problem. So anyway, but I just wanted to say that final piece.
Thank you. Anything else, Ms. Mallon?
I do agree with the points that Mr. Melnick was making, and it is difficult, but the policy, as Mr. Melnick said, was to try to bring properties into conformance with the current zoning. And I know it seems harsh, but we've done this before, and we have new build, where people have built the building with doors, and builders said, you can put the deck on later. And we've had to say no because it's simply, it exceeds lot coverage and it's not justified.
It's too close to the rear yard setback.
Right. So it's not
but in
just.
Your case, you have a deck already.
Yes, we do.
Place it. It's not apparently in jeopardy of imminent collapse. And maybe that you have to live with it.
Mr. Chairman?
Anything else, Mr. Owen?
Yes.
Well, I'm sorry. First, Ms. Freshman.
Okay.
Because we're still within the hearing.
Well, I'm sorry, by the hearing, I just meant taking testimony.
Okay.
Because I have discussion before the motion.
Okay, well,
This may be of the nature of discussion before the motion, too.
looking at the plat and looking at the pie chart, which is actually very helpful. Obviously, if you didn't replace the deck, you'd be all right. Looks like by the number, and the driveway is clearly the problem. Overall, I don't have a problem with replacing it because I'm very sympathetic to the need to do that, and the fact that when the rules change after you've already played the game, it can be perceived to be very unfair, but I think in fact we're held to that standard, and it's just unfortunate. But I think yes, I think it's probably got to get worse before it can get better.
Mr. Owen.
So I'm working under the assumption the hearing is over and we're in discussion on the board?
Yes.
Okay. So, well, I'm not sure that the votes count up the way I was expecting them to count. So, but anyway, so here's my take on it. I thought that the one we had last month was a difficult case, and we split 3-2 on it. I think this is a difficult case, and I think I think they can be distinguished, and I lean more favorably towards this variance than I did for the last one. And I think it's in part because of the strong connection that the applicants, I think, have reasonably made between the total lot coverage and the driveway that contributes so much to the total lot coverage. And what's troubling me is that, as my questions to staff at the outset suggested, if what we're doing is allowing or not allowing just a deck, and we're not talking about the driveway and the variance, but the justification for why it's a hardship or why this is a unique property or why it's special and not generally applicable is because this is not a general case for the driveway, then I'm troubled. I feel like the solution and the problem are not well enough linked. And and I think that Mr. Melnick hit it absolutely on the head, which is that there's a county board policy that we should reduce coverage for existing improvements on existing lots throughout the county. And they knew what they were doing when they put that lot coverage into this overall scheme, which was already established about what maintenance meant. And Mr. Melnick is exactly right that they expected over time more and more lots would come into conformity with the lot coverage. And I think that fundamentally, that's the county board's policy. And it feels really unreasonable with respect to decks in particular, because decks don't last as long as most other improvements. And lo and behold, that policy was enacted about 15 years ago, and decks go about every 15 years. So I wouldn't be surprised if we're about to see a wave of deck replacements. And we are not allowed to say that the application of the zoning ordinance to a particular parcel is unreasonable for variance purposes because we disagree with the overall policies of the county board. So if we think it was dumb for the county board to include decks in that overall scheme, and that the end result of this is that what's going to happen is driveways will stay but decks will go, and that's dumb, that's not our place to say, because that's the scheme that the county board put in place. So that's why I return to the question of, can something be done about the driveway? Because it seems to me that the driveway is bigger than it needs to be functionally, and it could be reduced. Now, could it be reduced all 307 square feet that it needs to be to allow the deck by right? I don't know, but it hasn't been explored, and we only got to ask this question tonight, and not a couple days ago to have it be better explored. But I think that might be worth exploring, and I would even go so far as to say, because we're allowed to consider the existing conditions of the site and the improvements on the site and so forth, that if they got the driveway down to 292 square feet, and then the variance they were asking for was like 0.1% coverage, that might be, a situation where it was unreasonable to strictly apply the ordinance. So I feel like there's a case to be made about the driveway, but what's requested in this variance as interpreted by staff doesn't connect the driveway in all the ways it needs to be connected to what's needed on this deck. And the final thing I'll say is, I also think it would be unreasonable to ask the applicant to take a backhoe and rip up the driveway that's already there just to be able to build this deck. Because again, going back to the policy statement that Mr. Melnick was describing earlier, the county board's overall scheme is that things over time fall into disrepair. So the direction I would go personally, and I don't know if there's support for this on the board, and it's speculative anyway because it's not what the applicant's currently asking for, but I would say what I would like to have is a variance that basically says, let the driveway fall into disrepair. You're not allowed to replace the entire paving of the driveway. When that paving goes away and disintegrates or whatever, and it's time to repave the driveway, you can't repave the driveway more than your initial coverage limit. But for the time being, you can rebuild your deck and let the driveway fall into repair. That, to me, that's the most just result in this case. But it's not what's being asked for, and I don't know that we can get from here to there. Certainly tonight, I don't see that we could get from here to there.
So that wasn't a motion.
Yeah, Mr. Chairman.
Ms. Mellis?
I find it too speculative to put into practice. You know, that we create, and I don't think we can do that tonight. You know, clearly we can't take that up tonight. But to suggest that at some point in the future, when the driveway goes, it can't be rebuilt without kind of knowing more about, you know, what the numbers are and if that's even reasonable. You know, if you're suggesting some kind of a deferral to explore this further, I have no objection to it. Obviously, if there's a way to get the numbers down, but I'm not sure, you know, but honestly, I don't know if I would go that way even if we had numbers. Because what we're saying is that we'll accept an increased lot coverage in the short term. And I think we're stepping out of bounds to say, I don't know that we really have the power to say we'll accept this in the short term with the understanding in the long term it gets rectified.
Mr. Chairman, I would just respond to that very last point by saying the statute specifically allows us to put time limitations on variances.
Yes. And so you would speculate as to when the driveway goes?
Well, I mean, his point is that it would be something that, like, when the driveway is in disrepair, it can't be rebuilt in such a way that the lot coverage exceeds the limits.
It could even be, and in any case, no more than 20 years, you know, or something. You know, 20 years or when the driveway
That
fails.
would be time for the replacement of this deck anyway,
Right.
Of the new deck.
Yeah, I'm having a little trouble with.
I see where,
I understand what he's saying,
well, but the point, I mean, you know, the case that they actually, the board, the county board actually did change the ordinance when we had those folk in those townhouses. And I think the point that you make is well taken with respect to decks are going to be in decline all replacement. Because I see that. And they do have a shorter useful life than a driveway, even an asphalt driveway, or certainly a garage.
Mr. Chairman?
Ms. Malice.
So, regardless of, you know, this specific case, I think Mr. Owen makes a point that the issue of decks might need to be re-examined in terms of the ordinance. But I mean, I'm willing to consider a deferral.
Well, let's ask him, what do you think in terms of exploring the possibility of reducing the size of the driveway? There are big saws that they have that cut asphalt, and they just cut off parts of it.
Just to be clear, Mr. Chairman, that's not what I'm suggesting.
No, I know, but
That would be one thing. You did suggest that if the driveway were reduced and it were only a fraction over the limit, that might make their reasonable restriction case stronger. And that's the immediate. I don't think we can do anything in terms of prescribing that down the road in 20 years the variance goes away and you have to bring it into compliance. I don't think that's. I'm not comfortable with that. So that's why I was offering, based on the suggestion of a deferral being something she might support if the applicant would even entertain the idea. If they won't, then they're discussing that.
But what's the purpose of the deferral? To do what? Just to recalibrate the driveway?
Yes,
To get numbers in front of us so that we can see what could be done.
and maybe they even offer.
How close you get to the limit? Okay,
Just an opportunity to explore. No guarantees that that would be
right.
acceptable, but just explore it.
What do you think?
And/or taking a little bit of the deck off.
So that we haven't explored either.
But I'm saying some combination of the two might work. Yeah.
What are your thoughts on?
So, I mean, I obviously our first choice would be to just have you grant us a variance. And again, I think we've satisfied the standard. I really haven't heard any.
Second choice.
Well, I think our second choice would be along the lines that Mr. Owen is suggesting, and maybe I'm mischaracterizing what the suggestion was, but if you could grant a variance subject to certain conditions, for instance.
Third choice.
Well, I guess our third choice would be to come back. I mean.
Would be
To defer and do this sort of investigation. I mean, our last choice obviously is just flat out denial, but
and that's where we're trying to inch it along, not terminate it, but inch it along, and perhaps that's possible.
Maybe at the end of the day, you'll still end up with a deck.
Because if you really need to replace it for your own personal safety, then maybe it can be smaller.
Maybe the driveway can be smaller.
Mr. Chair?
No, Mr. Melnick?
Okay. I think also what we're trying to instill in you that it is a very high standard for a variance. It is. And you probably heard that, just the hardship, unreasonably restrict, your utilization of the property. So it is a high standard. They're not easy to obtain.
It's not as high as it was. I think he pointed out accurately that the law did change. And
Yep.
it's not that taking
Yeah.
was necessary before.
But it is still it is still a high standard, higher than a use permit. And it's true. And that's something to keep in mind. That we're asking you to do whatever you can, just to try to bring this into compliance if possible. We're trying to help you out and give you different ideas.
Mr. Chairman?
Ms. Malice?
So, bringing it into compliance means that you'll return here. If you can figure out a plan that reduces the size of the deck and reduces the driveway, some combination, then you don't even need to come back. Then you can do that by right.
Or you can come back with something that is not quite,
Little bitty.
yeah. And then see what the sentiment is amongst these five folks.
Mr. Chairman,
Mr. Owen?
I move that we defer this item to the June BZA meeting.
Is there a second?
Second.
Thank you. There's been a motion made to defer this matter to the June meeting of the BZA.
It has been seconded.
Mr. Chairman,
Any further discussion, Mr. Owen?
I would just add that it seems like these applicants are extremely well prepared and sophisticated, and I hope that the guidance that we've given in the course of the discussion is helpful to you as you prepare alternatives for our consideration.
And I think you made a strong argument with respect to your finding that the driveway is the length of it is a burden.
Any further discussion?
I guess I would also say, I hope that you can work with staff to consider a scope of advertisement for the June meeting that would clearly encompass any possibility that you think we might be able to entertain for a necessary approval. So I think Ms. Malice is correct. Your best bet is to not come back at all because you found a way to do it by right, either the way Mr. Melnick described or some other way. But if you're going to come back, work with staff to make sure the advertisement is broad enough and proposed conditions are, in alternatives or you guys seem really up to this, based on the level of preparation I saw tonight. So put the whole menu out, right? And maybe something will get 3 votes.
Hearing no further discussion, all in favor of the motion,
Aye.
signify by saying aye.
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 All opposed? The ayes have it, the matter is deferred. Thank you very much.
Thank you.
See you in June.
Maybe.
Yes, maybe. Please call the next case.
Case number V-11454-19-VA-1 is a variance request by Ann C.R. Pera, the contract owner, to permit a setback of 9 feet to the wall from the right side property line instead of 12 feet as required, and a separation of 15 feet instead of 32 feet as required between building number 126 and building number 122 regarding a new Montessori school in existing buildings in the R5 and C2 zoning districts, premise known as 1022 South Highland Street. Staff recommends the board adopt the attached resolution granting the variance request.
Thank you very much. Questions of Mr. Rissy? Okay, I'm looking to my right, so I'm going to go to Ms. Malice first and then Ms. Freshman.
Do you know if the applicant was aware at the time of the board hearing that they would have to come to BZA?
Yes.
So the board had already factored that into.
Staff had met with the applicant before making application to the county board or the BZA.
And this was not something that the board could have included in their scope of
No.
advertisement? Because they've delegated it to us?
Correct. Correct.
Themselves?
In fact, it's a condition, the BZA's process is an explicit written condition in the use permit. So they said, and you can't go forward until you've gone to the BZA.
Thank you.
Mr. Chair?
Wait, first Ms. Freshman, then Mr. Melnick.
I don't really have a question, but I just wanted to make a statement on behalf of Montessori, with which I have a lot of experience as an owner, an operator, a parent, and a grandparent. And and I've also had some experience with a school that is in more than one building. This is a huge challenge, but I'm sure you're up to it. And I checked the zoning ordinance for definitions. So unfortunately, this doesn't meet the definition of a school. So, which is why throughout all the reports, it talks about a child care center, but at least one person up here understands that Montessori is not a child care center. Thank you.
Thank you very much, Ms. Freshman. Mr. Melnick.
Okay. And this is more of an administrative thing, because, and maybe the staff can address this, maybe the applicant if need be, but the things that I noticed are, it appears in the application that it states that Ann C.R. Pereira is a contract owner, and so she signed this disclosure statement as director. So my first question is, who is the contract owner? Is it an entity or is it Miss Pereira? So that's the first question.
I'll let the applicant answer that.
It's me. I'm an individual.
You're personally on the sale contract as the buyer?
Yes, we have since purchased the property.
Okay. Let's see. So the next thing that I noticed is that if Miss Pereira is a contract owner, like an equitable owner, that she is not listed under the ownership section. So there's the two people with the last name Iglesias and also Eric Whitland, but Miss Pereira is not listed there. So it just seems like this is incomplete.
Which is the applicant.
At least a disclosure statement.
If I may.
And also she has a title of director, which seems not correct if she is the purchaser of the property individually. So that's what I wanted to point out, because I know, there's a condition set forth for applications, they have to be complete. So I just wanted to bring that up.
If I may.
Mr. Rissy.
The disclosure statement and application were filed back in January, and the property has completed changing hands since that time. The application is true at the time it was made, that she was at that time the contract owner, and that the three owners listed are the folks who have the equitable ownership of the property at the time the application was made. We can update it now that it has changed, but I do not think that anything in here is incomplete at the time the application was made to you.
Okay, because my understanding, as a real estate attorney too, is equitable ownership includes the buyer of property. Because they have the right of contract performance, that sort of thing. So that's my point, is that the buyer of property ought to be in the table under ownership, and whether that can be rectified, or whether this is just incomplete and it needs to be re-advertised.
How was it listed? Yeah, how was it listed in the advertisement? It was Pereira was listed as the
Applicant, as she is listed on the
Contract owner.
and
Applicant.
contract owner who had equitable interest in the property at the time. And now, well, I was curious about what the ownership, the nature of ownership is now, whether it's a staying director. That sounds like that's linked to the school, child care facility versus the company, or kind of corporate or
Exactly. That's what I was thinking.
kind of entity status.
Yeah, like a board of directors. That's what I was thinking.
School director is like
Yeah,
a principal.
I wouldn't take that as a board of directors. I was thinking that more of a principal. That's the way I read it. I was wondering whether there was, a corporation or a LLC, or whether it's sole proprietorship, or how. But I also heard the point that Mr. Rissy made, that at the time of the application it was complete. Except I think it was in this there should have been a fourth name listed as a nature of interest, contract owner.
Yeah.
That would have.
I was also confused, Mr. Chairman, by the way the addresses were listed, because typically we have the point of this is to get back to the individual natural persons who are in control. And so usually we have people who are listing a home address or not a corporate address. And all three of these individuals, that it's not clear how I think what's meant here on the address section is that all three of these individuals can be addressed at 2519 Wilson.
That's why I read it.
But that's not a residential address. That's a real estate company's storefront. And so it's not clear to me, as you're suggesting, Mr. Chairman, that suggested to me that they might be affiliated through some corporation or partnership or whatever that was somehow, I don't know why Buck and Associates office is, how that's related to this whole transaction, or why that address was listed.
I think we've laid out some questions that hopefully Ms. Pereira can answer.
I do actually have some questions for staff in addition to that, but Mr. Melnick got us rolling on the financial disclosures, and I want to make sure he felt his question was answered.
Yeah. What is why is Buck's address listed with Ricardo, with the Iglesiases and Ritland?
It is the owner's company.
So the owner's
Then owners, yeah.
But that's not, there's no Buck named here.
What's the name of the company?
Buck and Associates, but it's Ricardo Iglesias, his wife, and the other gentleman, Eric Ritlin, who own that company.
Bill Buck doesn't own it?
Buck owns Buck Real Estate.
He may be a partner, but they are also.
So they listed an address for another business, for a business that they own in addition to owning this property. Is that what you're saying?
That is the address they gave me.
Okay.
Mr. Chair, may I ask a question? So,
I think the hole is getting deeper. Go ahead, Mr. Melvin.
okay, so this Wilson Boulevard address, is that your understanding that that's their business address? Like they have an office?
Yes, that is.
Do you know if they work for Buck Realty?
As I understand, they're partners in the company.
Okay. So that's what it sounds like. They put their business address on here.
It's a small building for a lot of people to have desks in.
I mean, who did you buy the property from?
The owners are listed there. They all own their property together.
And was Bill Buck their agent?
No.
It sounds like they're agents.
Mr. Iglesias was his own agent, Yes. Mr. Iglesias, his wife, and Mr. Ritland signed the documents at the sale.
So they bought the properties and are now selling them, and they work for Buck, or they're partners with Buck.
Interesting. I think that one of the requirements under the county ordinance is that the ownership of the property be fully disclosed. And I think what has happened is that this application doesn't fully disclose who the ownership is when, for example, a business address is listed for 3 individuals, and they are described in the nature of interest as being equal co-owners. And that's, and then of course, you were at the time a contract owner, but there's a problem with the disclosure. It's not. I don't believe it's an accurate disclosure of the ownership interest. Yeah, it may be just incomplete with respect to addresses because. Yeah, and see, it says provide a list just above that box. It says provide a list of the names, addresses, and nature of interest of all persons having equitable ownership interest in the estate to be affected. This is a business address, not those individuals' addresses. It's where they work, not where they live. And the ownership interest, the ownership disclosure would describe where they live, not for whom they work. Well, this 2330 South Quincy is your home, correct?
Yes.
Well, we don't. This is the Bucket Associates. This is curable. This is not terminable. This is a curable thing.
And just be resubmitted.
Yeah. So just so you know, this is the kind of thing that has to be corrected, but it doesn't impede your application. It may cause for a deferral, but it may not. But it certainly has to be corrected. So,
Mr. Chairman?
let's go with Mr. Melnick and then
Sure.
Mr.
Take your time.
Also, it creates ambiguity, like we were saying. With director, is that an entity? Is it her individually? And I think, the whole purpose of this is so the public can see, are there, what is their interest? Because if, different entities might have different interests. Is it corporate? Is it individual? People, it's a whole different way of looking at things for a lot of people in that case. And it's just, I think it's so ambiguous and so incomplete that I think it would need to be advertised again, just so people can get a true idea of what they're dealing with here. Is it an entity? Are they individuals? That kind of thing.
Mr. Chairman?
First, Mr. Owen, and then you, Ms. Mellis.
Mr. Chairman, my question doesn't relate to the financial disclosure, so if my colleagues are finished with that.
All right.
I know you do have, okay.
Disclosure.
Ms. Mellis.
So is 1022 South Highland Street the address for all 3 buildings?
So this is one parcel that has 3 buildings on it that have 3 addresses. So 122 is one of the building addresses, but is an address of the parcel.
And when it says parcel address, it was just pick one of the 3 addresses?
That is an address of the parcel.
One of the 3, okay. And we presume that the entire parcel was owned by the same, all 3 addresses were owned by the same entity?
Yes, the one parcel was under ownership by the 3 individuals in this case. Common ownership.
Okay. Well, I guess Mr. Melnick suggested that this matter may need to be re-advertised. Were you making a motion to, for that purpose, Mr.?
I believe it would be a motion to defer. Just for that purpose, to set out in public, the correct information. So I think it would be a motion to defer.
Can I just ask a question? It's advertised as a contract owner, and I think Mr. Rissy said at the time that this was filed, that was the case, and it was still owned by the previous owners. So I understand about correcting the paperwork. I don't understand about re-advertising it and holding it over. Unless you make the determination that if the sale is now complete and she is the owner, then do you have to eliminate contract from the advertisement because of that?
Nunc pro tunc, now for then. I just offered that up in terms of whether you were going to make that a motion to defer for the purpose of determining whether there was support for that, or if there was another way to get to an accurate disclosure.
Mr. Chairman?
And what purpose is served by now suggest, in as much as the property has changed hands, by advertising that the Iglesias and Mr. Ritland at a point in time did have an ownership interest? I don't.
Mr. Chairman?
I'm just rolling around. Mr. Owen?
There may be other reasons for deferral, so maybe it would move us along to go ahead with further consideration, and maybe there'll be different votes for deferral based on other factors. May I ask a question of staff?
Go ahead. Or are you still?
Mr. Miller made a motion. He has no second.
Well,
Did you make a motion?
I didn't necessarily recognize it as a formal motion.
No,
He said it would be a motion to defer and not to. Were you making a motion?
Well, no, I wasn't technically making one. I was just saying what I thought kind of.
You were suggesting that's what it would be, and it would. And there may be other grounds.
Mr. Chairman,
Mr. Owen.
if I may ask a question of staff.
Go ahead, please.
Yes, so in the staff report, page 5, there's a suggestion that the change in the location of the boundary between the C2 and the C2 and R5 zoning in 1950, quote, was likely an oversight, end quote. What is the basis for thinking that this was an oversight rather than an intentional change?
It is the only parcel along this row of structures that was included in the C2 zoning. Everything else was fronting.
What I see is that the boundary between C2 and R5 along these 3 blocks that were in the attached photo it went up and down and up and down in multiple places. Multiple parcels were reconciled, and it looked like someone was going along very carefully both times to zig and zag the line. And so I'm wondering, well, is there something about this particular zig and zag? So what you're saying is solely because it split a property line, you assume that was an oversight?
No, it is because it is the only property facing South Highland Street that was included in the C2 zoning when all the other parcels that were changed to C2 zoning were facing Columbia Pike.
And it's residential use.
Thank you.
So it's the frontage boundary change.
So I see the rationalizing from Columbia Pike that the zoning change was creating development depth along Columbia Pike. And it was deliberate to move it back.
That wasn't staff's position.
It wasn't staff's position?
No, I mean,
70 years
it's
ago.
fine to disagree on that, but staff's position was that it may have been an oversight because of its residential nature and facing a different street than the others.
But we don't know what the discussion was back then, yeah.
Of course.
I would say it's more likely, from my point of view, that we were just creating development depth on Columbia Pike. Because we did that in other places later.
Mr. Rissy, thank you very much for that answer. That's helpful. My next question is, if the variance were to be approved as advertised, would the parcel owner have the right to tear down the existing structure and replace it with an otherwise conforming structure so long as the new structure was no closer than 9 feet to the right side property line and 15 feet separated from the building with the address 1026 South Highland Street?
Absolutely not.
Why is that?
Because our view is and always has been that the variance goes with the land and is for the structure that is advertised and reviewed by the Board of Zoning Appeals. They can tear down and build this exact same structure and its configuration, absolutely. But they cannot tear this down and build a new structure with the same setbacks that you are giving them tonight. It is consistent with what we have done before. We have made applicants come back to the Board of Zoning Appeals for changing the location of windows in applications that they have shown you, because what you review is what you are approving. And so a different structure that you did not review is not what is being approved.
But typically, we have a condition in the variance that specifically says shall be done in conformity with the plan submitted, but there was no such condition proposed for this variance. Is there a reason for the different treatment on this one?
The staff member who wrote the report did not feel that the belt and suspenders that is typically that condition was necessary in this case.
Would staff object to including the standard condition? Is there any reason not to?
No.
Okay.
Any more questions of staff?
Yes. The proposed resolution of approval states that the applicant must obtain a certificate of occupancy pursuant to use permit U-3529-18-1 in order to perfect the variance. Is there any reason why we should not set this variance to also expire when the use permit expires?
Other than the difficulty in enforcing that, no.
I mean, I would imagine if the use permit expires, it'll be because there's been an ownership change or a use change that will require other kinds of approvals that will note the variance change.
That is certainly possible, but it could be a new use wants to use the same structures as well, just like this use.
Okay. I'll pause for now.
Any further questions of staff? You're pausing. Ms. Malice?
Just, not in this application, but in the associated use permit application, there's a GLUP table showing what the GLUP is here. And the general land use plan. And I'm curious that the GLUP shows Highland Street as being straightened out. And I don't know that it has any bearing on this case at this time, but the general land use plan does have Highland Street, so, because right now it's an offset intersection. And so property lines won't change, but there will be changes if this GLUP were to be realized.
Correct.
Any further questions of Mr. Ricci?
May I clarify, though? Just in that GLUP drawing, it does appear that South Highland actually changes on the other side of Columbia Pike to meet this street frontage rather than the other way around. It appears to be curving up above Columbia Pike.
Their property's below Columbia Pike, right?
What's that?
Their property's below Columbia
Correct.
Pike on this. But the intersection's been rationalized.
Yes.
So, in fact, the road would cut someplace else, not here. And I think it would be on their property if this was to be realized. And this policy document doesn't affect zoning at this point, but it's just a future plan for the.
Anything further, Mr. Ricci?
No, sir.
Okay. Welcome. That was a whole lot of administrative and preliminary and some legal questions that we were kind of wrestling with. Welcome. You can please make a presentation with respect to your to the
involved. Good evening. This is my mom, Chris Pereira. We started Meta Montessori School in 2013. From the very beginning, we wanted to be located in South Arlington. Firstly, because this is where we've lived and this is where we've always lived. And secondly, because we felt there was a real lack of Montessori schools, quality Montessori schools in South Arlington. So initially, we leased a space, renovated it, and opened in 2013. From the beginning, the response from the community was overwhelmingly positive. Our children interact with the seniors at the Walter Reed Community Center, and they partner with Patrick Henry Elementary School for the annual Snowflake Drive. We've built really good relationships with the residents and businesses surrounding us. We're currently at full capacity, and we also have a very robust wait list. There's a strong demand from families to increase our capacity, and last year we think we found the perfect property. It is located just 1.5 blocks from where we are now, and the property allows for off-street drop-off and pickup, as well as off-street parking for our staff. Most importantly, there's ample outdoor space for the children to play and garden and do their work. Before purchasing, we consulted county zoning and the child care departments regarding the feasibility of the site for a preschool, and they gave us the go-ahead. After much deliberation, we concluded that the only way we could use this site for a preschool was to renovate the existing houses, as the new construction simply wasn't in our budget. We've since obtained a use permit from the county, and we have presented our plans to the Douglas Park Civic Association, which is the neighborhood the site is located, and they voted unanimously to support our project. The board to consider the unique split zoning situation of this property, requested variances and use permit, so we can continue to provide quality Montessori in South Arlington, our community.
One more thing to answer Mr. Melnick's question. Director there refers to the director of Meta Montessori School.
As principal, another term for principal.
And also to answer Mr. Owen's question, we simply cannot afford to build new. That's why we are renovating the houses. So no new construction in the near future.
You still have 2 minutes and 18, more than 2 minutes left if you need it. Okay. You'll have ample time as questions come up. Ms. Malice?
Mr. Chairman, I don't know if the applicants will remember, but I recall now that I'm acquainted with the applicants. But I wanted to disclose, that and state for the record that I can hear this application fairly.
Thank you very much for that, Ms. Malice. Any questions of the applicant?
Mr. Chairman, when the county board approved this, was it on the consent agenda? Did they do that without having to hold a hearing at the beginning of the Saturday morning? So there was no controversy at the county board?
No.
Is that right?
No. Yes.
Mr. Rissy.
I actually have a question. I'm hoping the applicants could help clarify some of the disclosure issues. I was trying to find a copy of the application that went to the county board for the use permit that they have received from the county board. Yes. Unfortunately, in the copy that we have, they do not include the disclosure statement that was submitted to them. But if you notice the disclosure statement that is in your application, it is actually different than the disclosure statement that you typically receive for applications to the Board of Zoning Appeals. And I believe that is because it is the same disclosure statement that they submitted to the county board for their use permit. It may not answer all of your questions. I understand that. But if the applicant...
It's a copy.
Yeah, could clarify if the disclosure statement that you submitted to the Board of Zoning Appeals is the same that you submitted to the county board for the county board use permit.
I'm sorry, didn't know it was different.
Well, I think that they are the same, and I'm just looking if you can confirm that suspicion, because it is on their form that you have filled out.
Oh, okay. It must be. But we did submit 3 letters.
It's a different form.
It is a different disclosure statement, and so that, the point of providing that is to say that, well, if it was good enough for the county board, it's presumably good enough for us. Maybe they didn't have the sharp eyes of Mr. Melnick down there. Thank you very much, though. Thank you for obtaining that. That is helpful information, though. Any other questions? Mr. Owen?
I want to steal Ms. Miles' thunder if she has questions.
I'm good.
Okay. We typically we typically strongly encourage neighbor feedback.
Yes.
So I didn't see any on this application. Now, I recognize that all of the neighboring uses are institutional uses, but maybe I missed it in the application. Yes, go ahead.
May I answer that? We have reached out to all the neighbors. I have been in contact with the Oxumite village, the Ethiopian community, since November of last year, and they have promised to give me a letter of support even 3 weeks ago, and they haven't. I have the emails. The Days Inn Motel was willing to give it, but it was too late to meet the deadline. The other two businesses, the SunTrust Bank and Dunkin' Donuts, the workers there wouldn't put us in touch with the owners. We couldn't get hold of the owners, but we did.
Charlotte? Aren't they in Charlotte, North Carolina? Their headquarters?
Who knows how the bank sliced it?
Yeah. And actually, I'm curious whether they actually own that building because their office is upstairs.
Yeah.
They may be a tenant also.
Right.
We did.
Or did you determine that SunTrust actually owns the building?
They don't.
Okay.
So we went up to the African American Museum and tried to get the owner's information through them, but still were unable to do so. But we did do a presentation to the Douglas Park Civic Association,
See that.
which we are part of, and spoke to the neighbors who live on Highland Street, and they were very supportive of the project.
I have no further questions for the applicant, but I do of staff, depending on the direction we go.
Thank you, Mr. Owen.
Okay, so in this is really unusual, this case, and what's being said about, this C2 being a part of this, being an oversight, because, I think that laws are presumed to be intended, and, and perhaps that this, we have no information on it, but whether or not somebody had thought through that in order to do something different with this, you would need a variance, they'd have to, meet the variance standards. It's hard to say, because I'm personally, I was looking at this, and of course it says the only reason we're talking about a variance is because this one lot is commercial.
Right.
And so it just seems to me we can't speculate as to whether or not this really was an oversight. And I'm actually having a hard time with the unreasonably restrict utilization of the property and with hardship. Because I don't think we can say, well, it's a hardship because they went before the county board, and now they'll have to go back again. They'll have to reconfigure the property because these are houses. They're structures. They're residential houses. So presumably they could continue to be used for that purpose. So those are my thoughts.
Service commercial.
Yeah. But I think even a residential house, can still be used for residential purpose in a commercial zoned area.
That's true, but it's also contrary to county policy. I mean, the underlying scheme, land use scheme, is that C2, the highest and best use of C2 property is non-residential.
Perhaps this structure, house structures, my old office was a house converted to an office.
Yep.
Then that can be done. So it's, it just seems to me that these structures, can be reasonably utilized, the way they are. So I'm having a hard time with those standards.
Mr. Rissy.
If I could clarify, this structure that is at interest in this variance could not be used as an office. It is the creation of the non-residential use that is requiring the setbacks that they cannot currently meet. That is the reason we are here with the variance today. If it was continued as residential, that's different, but if it were to be any commercial or any non-residential use, they would be here for this variance.
But if the change in the zoning boundary was not an accident, then the most likely intention of the county board was that this structure would be demolished and a true commercial structure would be built in its place, possibly consolidated with the property to the north. I mean, that's, if you just look at the map, it's like now it's attached to the north, right, in terms of its planning. And that's not and especially for C2 zoning in Arlington, that's a really common situation. A lot of C2 in Arlington is, it's highways that are state roads still, even though most everything else is a county road. And you have this little strip off of the main road that cuts parcels into lots that are just barely under the developable lot size for C2. I mean, like C2 is like the cats and dogs zoning category for Arlington that has a lot of these kinds of weird issues.
If I may respond to that,
Yep.
I would say even if that were the case in 1950 when it was rezoned, I think it is an entirely different situation now that this is one lot with 3 structures on it, a third of which is C2. Because now we're talking about having to subdivide the lot to sell it to the northern half.
When was the lot consolidated?
In the 1960s.
Okay, well, and then whose fault is that, you know?
Not the applicant's,
The zoning when it was consolidated.
but it was not the applicant's fault.
But that's not a reason to presume that the county board was being irrational in setting the boundary there or having a policy intention for how it would eventually be redeveloped.
No, but the impact it has on the applicant today.
Right, but I'm answering a different question, which is that the Board of Zoning Appeals is also required to consider the overall policy scheme of the county. In creating the ordinance, oddly enough, I don't know whether we can give weight to the fact that the county board approved a use permit. Like, you'd think that if we're looking at what's the policy of the county board, that we could look at not just what ordinance changes they made in 1950, but what they did a month and a half ago in approving the use permit here, right? That's also a policy statement by the county board.
Kind of updating of the 1960 policy statement in a way.
You would think. And so I mean, I have some ideas about this, but I wanted to just leave it as that question for now. So I will also just note, since we're here in open session, that the whereas clause here in the proposed resolution, I don't think is adequate for our finding. It says that the BZA finds that the granting of this variance, and there's a typo here as well, but I think it was meant to say, would reasonably allow the utilization of the property pursuant to the special exception use permit. And so I've got a couple problems with that. Fundamentally, that's not the standard in the statute. Right. The standard in the statute is that the strict application of the zoning ordinance would unreasonably restrict the utilization of the property, which is not the same thing as this is a reasonable utilization of the property.
Well, it could be supplemented. A strict application of the ordinance is an unreasonable restriction because the county board has changed the use.
Well, yeah, I mean, that can be rephrased, right? Yeah. But it needs to be rephrased even to meet the statutory standard. Right. And the reason I want to mention it now is because I believe the previous application, which I forgot to mention, also has a similar problem in its first whereas clause. And since we're not allowed to talk about variances outside of our meetings, I want to make sure that for all variances that we might consider that, that's cleaned up. The second is, I don't know what it means pursuant to special exception use permit U-3529-18-1. What's the meaning of those words? Pursuant to.
Because they passed. That's the way I read it.
Okay. Because.
It's really a way to slip in.
Because
the county board is supporting this and thus.
Because of the policy statement.
Yeah.
It's unreasonable to strictly apply the zoning ordinance because the county board has passed a use permit. Okay. Is that what staff intended?
I agree with that.
Okay. Good answer. All right. All right. And then my final. So my final thing is not a question; it's a thought, which is, this is a really weird parcel. And I am very concerned that if we don't write this variance properly, that we could make things even more complicated for future generations. That I don't want to create a variance that if the parcel later redevelops as a McDonald's or something, that then the county board or the circuit court or a future BZA has to grapple with a variance that unintentionally created rights that further wrap everything around the axle here. So what we have is a zoning boundary change that is so weird that current staff thinks it must have been unintentional. Then we have a parcel consolidation of 3 houses into a single lot that crosses a zoning boundary, which was a weird thing to do, in any circumstance. Now we have a Montessori school, which congratulations to you for having the creativity. Only a Montessori school would have the creativity to use this site in this way and figure out how to make it all work. So, of course, it's a Montessori school that threads the needle here, right? But this is obviously not the long-term vision for Columbia Pike on this parcel as any of the plans and ordinances have. And so and staff has not put in the usual belt and suspenders of this is related to the current plats, this expires with the use permit. There's no connection to what's actually being done. And in fact, it's only in the whereas clause that the use permit, well, it's in the whereas clause, but anemically in condition number 1 that the use permit is referenced, right? So if this stops being a school and the use permit lapses, and like I said, McDonald's comes in and wants to use, I don't want this to carry over. So I'm fundamentally in favor of this variance. I think that the reasonableness requirement is met, but I don't support the proposed resolution because I think it could really dig us all in deeper by being too unconnected to the very unique circumstances that are being presented tonight.
Mr. Rissy, first let me ask Mr. This question might be.
Okay, so I have a question for what Mr. Owen was saying about, whether the zoning ordinance unreasonably restricts the utilization of the property. Are you basing that on the county board's action? Or what are you basing that on?
I think that what we're facing is a parcel that is unusually situated and has unusual structures given its zoning and shape and size and configuration. And so fundamentally, I think that this is a very atypical parcel, and so atypical things need to be done on this parcel. And I think that it is for the use that is proposed, if we're connecting it to the use, right? If it's okay to connect it to the use and say a Montessori school operating in buildings that have been on this site for decades that are otherwise allowed and that the county board has just voted uncontroversially to do, and not having any structural changes, but just sort of letting the existing land and structures stay the way they are and have different activities conducted in them for now, that to limit that by saying, oh, well, really the buildings should be another 15 feet apart on each side to allow that because of the nature of the zoning order. I just think that that's not, I don't think that that was contemplated by the county board in 1950, that would be the outcome. I certainly don't think it was contemplated by the county board in 2019. I don't think that that's a natural intended consequence of the zoning ordinance as enacted with the policies that the county board, and in addition, the GLUP, the Columbia Pike Revitalization Plan, all the other county policies that have been made over time. I just don't think that denying this variance would lead to a natural and intended result that's within the general scheme of the zoning. Right. So I think that there's a variety of exceptional circumstances here that make this use at this time in this configuration with this history, with these buildings, all of those things together, it's like, who could possibly be hurt by this, and what larger policy could possibly be undermined?
Okay.
So,
Thanks for the explanation. I agree.
Ms. Mallon?
That's gonna be some motion.
So, you discussed or mentioned earlier connecting this variance to the use permit in terms of expiring,
That's what that first whereas does.
so that there would, a McDonald's could not come in and tear anything down and retain the rights that we would give through the BZA action.
It now seems to me that the greatest danger is that a McDonald's could move in and not tear anything down and just operate in the building because we've excused it of normal commercial distances, and that would be the problem, that because staff has made the claim that tearing down the building, even if we don't say so like we usually do, that tearing down the building wouldn't be allowed. But mostly in what I'm saying is I have no idea what's going to happen here, and I have no idea how the zoning ordinance is going to change or how interpretations of it are going to change. And I'm just really nervous about assuming things in the tape recording record today that 19 years from now will be lost and people won't be able to put the pieces back together.
I would like to emphasize the point that Mr. Owen made there, that it is staff's position that the variance is tied to the structure and lot. So if McDonald's came in, unless this is a new future McDonald's that wants to reuse 70 old houses, they would not have the same setbacks. And I would like to emphasize that the only reason that this application is necessary is because they are reusing this structure. The commercial setbacks in this district, if there were no openings in this wall, are non-existent. So a new structure could be built closer to the property line if it did not have windows. It is only because this use is trying to reuse this structure in its current location, and yes, I'll leave it at that.
But, let's say the notion of McDonald's may be far-fetched, but there can be another commercial enterprise, right, that could move in.
Correct, but any commercial enterprise could tear this house down and build a wall on the property line. Any. If it didn't have windows and openings, that would be permissible under the zoning ordinance.
So I think what we're left with is finding a way to tighten up the resolution, and I don't know if that's something we can do tonight. Sure. Can we?
Yeah, so I'll just say that if Mr. Melnick makes a motion to defer because of the financial disclosure, I'm going to support that. And I don't know if there's 3 votes for that, but I will. So I just want to put that out there. But I am also happy because if we do have a deferral, we should have it be the most constructive deferral possible. I'm happy to give additional guidance about the proposed resolution as well. So I would, in the first whereas clause, I would just rewrite it to say, whereas the BZA finds that strict application of the zoning ordinance would unreasonably restrict utilization of the property in part because of the approval of use permit U-3529-18-1. And then I would add,
Because we got a use permit here too.
yep,
By the county board, because that's the first use permit. There's another one for this property, this use.
and I would add 2 additional conditions to the condition language. I would add a condition number 2. The applicant agrees not to modify the placement of any exterior walls. Actually, I wouldn't say the placement. The applicant agrees not to modify any exterior walls. And condition number 3, this variance shall expire if the main, I'm sorry, I need more, sorry.
With the use permit.
This variance shall expire if the main building on the parcel is enlarged or removed. And then 4, this variance shall expire if the use permit U-3529-18-1 expires.
Is that a motion? Can I ask a question of the applicant?
Go ahead, Ms. Freshman.
Ladies, given the extensive renovation that's going to be required, can you reasonably expect to get a CO in 1 year?
What's
Certificate of occupancy? The proposed resolution says you'll obtain a certificate of occupancy pursuant to the board's use permit for a child care center by April 17th, 2020. And typically, our approvals do have a 1 year, but yeah. But the CO is different because a CO means you've got to get it all done, all three of them, and get your CO in a year. That seems a little tight to me, but
That's what the county required, though. Is that what their use permit from the
is,
county board says?
is this the county's? Did they say a CO in a year? I mean, if they did, they did, and you have to hustle. But that seems tight to me for this extensive renovation. Whereas usually we have one that says if you don't start within a year, then
It says February 2020. The county use permit.
well, that presumably was a year from when your county board was in February.
yes, January.
If that's what they said it. It just seems like it's unusually tight compared to some of the restrictions we usually place on these actions.
That's the date of the drawings.
Do you know, Mr. Rissy?
I don't know for certain. I don't see that as one of the proposed conditions in the staff report that I have here. I don't know if it was added at the hearing or anything like that. I'm sorry.
Okay, well,
Ms. Bowles, you were reading from the,
I was,
First use permit.
I'm sorry. I was looking at the county board staff report, and they recommend, but they do not put in the conditions. And I don't know if any other conditions were added, but staff recommends that the use permit for the child care center, subject to the conditions listed, is reviewed in 1 year, which is a pretty standard.
sure, but that's entirely different from what this says, which says that they have to have a CO in a year from tonight.
What are you reading from?
Resolution,
First condition.
the only one at the moment.
Where did that come from, Mr. Rissy?
I believe it was meant to be in line with the conclusion of the staff report for the county board use permit, but staff is not opposed if the BZA decides to modify that condition.
So the recommendation that Ms. Malice just read, you think it's supposed to be in line with that?
Or were there other conditions added at the hearing?
I don't know of any other recommendations that were added at the hearing.
couldn't have been because it was on the consent agenda.
Consent,
Well, let me
it was
ask the
consent.
Is it your understanding that you were told you have to have it completed within 1 year of when the county board took action on the use permit?
Yes,
That's what they told you?
that's what I have read, yeah.
So that's February, so that's really 9 months, not even a year. From now, assuming everything went forward tonight here.
Yes, so extensive renovations, we are renovating the interior and then creating the drop-off and pick-up in the front and parking. So from what we have heard from the contractors, it should be done within 4 to 6 months.
Okay,
You already have a contract in place with a contractor that says 6 months.
Not exactly the time, but we have a contract with the contractor. We needed to, in order to buy the property, we needed to provide that information for the bank.
their estimates are always overly optimistic.
That sounds.
I think 9 months to renovate 3 dwellings and a parking is not an issue.
Get a certificate.
The rear deck isn't an issue. But yeah, that's because that's a tough standard to get a CO. I mean, you already know that from your existing. I find that very limiting, that date. finished.
So a use permit review in 1 year without a building being completed. I guess that would be a progress report.
So, Mr. Chairman, I think their votes seem to be there for approval here, but it would be maybe cleaner if we could have a deferral to get all the paperwork straight.
My problem with that is if they're under a C of O deadline, a deferral puts them in a worse position.
Because you think there's things they can't start until they get our approval?
Exactly.
Is that true?
Yes.
What are you waiting for our approval to do next?
Well, they can't submit plans to building without being sure of approval for the setbacks.
I see. Okay. Well, then, in that case, I'd want to, Mr. Chairman, if you're so inclined, I'd want to see if Mr. Melnick wants to make a motion on deferral, see how the vote goes, and depending on that, then I might be prepared to make another motion.
Okay, well, let me just say, any more discussion, any more questions of the applicant or staff right now? Okay, I'd be happy to entertain any motions that the board may want to make.
In reference to deferral, is the earliest feasible date the June meeting for advertising and so forth?
The items for May have been advertised today, actually. There still is enough time to do a special advertisement that would add this to the agenda.
Okay. Yeah, so just to correct the notice provisions of the application and the disclosure, to give the correct information about owners, when, presumably the revised application and disclosure will be made. So I'd make a motion to defer at the case number. Defer case V1145419 VA1. Defer it to the May 2019 BZA meeting.
Second.
Any further discussion of the motion to defer this matter to the May meeting of the BZA? Hearing none, all in favor signify by saying aye.
Aye.
All opposed?
No.
Nay.
Mr. Chairman,
Sounds like that was 3-2?
yes,
Okay.
with Mr. Melnick and Mr. Owen dissenting.
Okay, any other motions?
Yes, Mr. Chairman, I have a motion.
Owen?
I move the proposed resolution with adjustments. Specifically, that the second whereas clause should read, instead of what's there, whereas the BZA finds that strict application of the zoning ordinance would unreasonably restrict the utilization of the property, in part because of the approval by the County Board of Use Permit U-3529-18-1, and furthermore, that in the resolve clause that the first condition be modified to, do you just want to have a later date?
I'd prefer, June or July or something that gives them
How about November 1, 2020?
Okay. You don't need that much time. You'd rather open in September. It's okay. I think you need the time.
In that way, right, okay. So so to change the date in condition number 1 to November 1st, 2020. To add a new condition number 2, the applicant agrees not to modify the, I'm going to say configuration of any exterior walls. And just for the record, what I mean by configuration is things like adding or removing windows, moving the location. I don't mean repainting. I don't mean recladding, but some kind of meaningful structural change.
Like closing one door and cutting a hole and making a door in a different place?
Anything that would be a code type change.
Okay.
As opposed to cosmetic.
Right, as opposed to cosmetic. So the applicant agrees not to modify the configuration of any exterior walls. This variance, new condition number 3, this variance shall expire if the buildings on the parcel are enlarged or removed. And a new condition number 4, this variance shall expire if the use permit U-3529-18-1 expires.
Second.
Oh, could I just ask for clarification on new condition 3, that the variance shall expire if the building on the parcel are enlarged? Would this be exclusive of the proposed rear deck?
Enlarged beyond what's been shown in the drawings.
Okay.
Reference the
Is
drawings,
that
that would be
acceptable,
good.
Mr. Owen?
Yeah.
Enlarge beyond what's presented in the drawings?
Dated, whatever.
What is shown in this application?
Yes.
Yeah.
No, I have a question, a clarification.
Let's hold on for a second. Let's get the motion on the floor and get
Well,
it seconded.
Mr. Melnick might be asking for clarification on the motion.
Yeah, okay, so with the third condition, I'm sorry, I believe it's the fourth, expire if the use permit expires.
Yes.
The
It-
board, the
and-
board one.
I didn't know under what conditions it would expire.
I think it would expire if the parcel were no longer being used for a daycare center.
Went out of business.
Because wouldn't it be better just to say that, to clarify that? Because I haven't seen the use permit, but it just seems to me if that's what we're getting at.
I wanted to do that because the county board often will modify use permits over time. And so if, for example, I mean, we've already heard that they're technically applying as a daycare center, but they're really a school. So I don't think that I would be concerned about using the right term of art, whereas literally naming the use permit is super clear about what we're talking about and also gives the county board the discretion to make any subsequent political decisions.
I'm wondering, does it say it under its terms that it expires if that use stops? Like it's automatic expiration?
This is a use permit for a child care center for up to 90 children. It's specific as to what the purpose of the use permit is. So if it were not to be a child care center or exceed the 90 children, I would presume that the use permit, that whatever would be in violation of the use permit, it wouldn't legally be able to operate as such.
But if they sold it, it would still remain, because I did that.
You could sell it
As long as if it remained in that use.
Yeah, that would make sense. And I'm going to suggest, Mr. Rissy, that the use permit be made part of this BZA record.
Understood.
The board one, the board use permit.
Yes.
Because we still have one coming.
Just wondering if the word expired is the right word, if it expires. It sounds like we're more just talking about the use changing.
Well, that's, I think, a term of art. Use permits expire for a number of different reasons.
Okay.
It's okay.
It could be, the board could, there could be neighborhood opposition, and the board pulls the plug on the use permit.
Could be repeated zoning violations that result in the board reconsidering.
They could be reviewed.
That's a common one for bars.
Yeah,
Technically, a revocation might not be the same as an expiration, I guess you can make the argument. But is that what you're getting at, Mr. Melnick?
Just, I just want to make sure we're covering all the possible bases that we want to cover. And I, of course, I don't have the ordinance right in front of me with the term of art expire. But that's all I'm saying. It's just, since it sounds to me like the members here that are familiar with this term, that if it stopped being used as a daycare center, then this would expire. It would just expire and go away.
My understanding, and actually maybe this is another question for staff, is that if the use changes, that the use permit would expire. Is that correct? If it moves to a use that doesn't implement the use permit, does the use permit expire?
Or is it revoked?
I'm actually wondering if some of my staff here can help clarify that position. I can't say for certain. And I'm getting a shrug from staff, so.
Couldn't we just condition it on the use described in the use permit?
Well, because the use permit, let's say the use permit is modified. The applicant comes in and says, we'd like 100 children instead of 90.
take it up to the third grade.
And it shouldn't revoke our,
I think I get what Mr. Milnick is going after, and I would say we should probably do both. So I would say that number 4 would then read, this variance shall expire if the use permit U-3529-18-1 is no longer in effect or the parcel is no longer used as a daycare center or school.
Yeah, okay, that sounds good.
There you go.
Okay. So I'll take it from the top just for the sake of clarity, Mr. Chairman.
Okay.
I move in case V-11454-19-VA-1 that the board adopt the proposed resolution with the following modifications, that in the second whereas clause that it read, whereas the BZA finds that the strict application of the zoning ordinance would unreasonably restrict the utilization of the property in part because of the approval by the County Board of Use Permit U-3529-18-1, and then moving down to the resolve clauses in the first condition to strike April 17th and insert November 1st. Add a new condition number 2, the applicant agrees not to modify the configuration of any exterior walls. 3, the new condition number 3, this variance shall expire if the buildings on the parcel are enlarged or removed beyond what is shown in the application. And a new condition number 4, this variance shall expire if the use permit U-3529-18-1 is no longer in effect or the parcel is no longer used as a daycare center or school.
Second.
Thank you very much, Mr. Owen, and thank you, Ms. Freshman, for seconding that motion. Any further discussion? Ms. Malice?
I was wondering if we needed to acknowledge Mr. Melnick's concern about disclosures and if there's any cleanup that needs to be done. It doesn't have to be part of the motion, but is that something that can be done after we conclude this item?
In what manner? What additional?
Clarifying ownership and...
Nunc pro tunc.
Yeah. I guess I would want the actual addresses of the co-owners, the Iglesias and Mr. Yeah. And then the addition of your name as a contract owner at the time of the application. What other deficiencies were there, Mr. Melnick?
Also, if she was not, if it wasn't, it was just her individually deleting the word director.
Yeah.
After her name.
And also, I noted that the Montessori school is an LLC. Are you the only member manager? Okay. Right. So, yeah, strike director and just your name as the contract owner at that time. That could be a supplement to the disclosure. Just you're required to submit that to for inclusion in the record.
Mr. Rissy, I think you follow where we're going and can assist.
Yes.
Any further discussion? Hearing none. All in favor of the motion to approve the subject variance signify by saying aye.
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 All opposed? The ayes have it. Now, the next case, Mr. Rissy.
Case number V-11454-19-UP-1 is a use permit request by N.C.R. Pierre, the contract owner, to permit a setback of 8.5 feet to deck from the left side property line instead of 16 feet to deck as required, a setback of 8.5 feet to the wall of the building, 7 feet to the eave instead of 20 feet to the wall, 16 feet to the eave as required, and a setback of 36 feet to the deck from the rear property line instead of 46 feet as required, 48.6 feet and 48.7 feet to the wall of the buildings instead of 50 feet as required from the rear property line. A separation of 15 feet instead of 36 feet is required between buildings number 1030 and building number 1026 regarding a new Montessori school and existing buildings in the R5 and C2 zoning district, premise known as 1022 South Highland Street. Staff recommends that the board adopt the attached resolution approving the use permit request with conditions.
Thank you very much. Questions for Mr. Rissy?
Mr. Chair.
Mr. Melnick.
So I would just note that the same issues are the same on this case as the other about disclosure.
Yes. So cure that in the same manner as was was described for the variance, if you would. And any further questions of Mr. Rissy? The floor is yours, Ms. Pereira, for any additional comments now with respect to your use permit.
I would just like to say the decks that we are hoping to build is to provide ADA compliance access to all the 3 buildings for children with disabilities. That is the main purpose, is to have ramps from the parking in front to the decks, and then they can enter through the back.
It wasn't clear to me. Will there be any covering over the decks? Awning or?
No.
Okay. So one of the conditions will be that you won't be able to build over or enlarge
Or enclose.
the rear deck, or enclose, or screen it, or any of that. Okay.
Mr. Chairman,
Mr. Owen?
I'm prepared to make a motion.
Thank you, and Ms. Malice is back. Please, I'd be happy to entertain it.
Mr. Chairman, in case V-11454-19-UP-1, I move that the Board of Zoning Appeals adopt the proposed resolution contained in the staff report with one amendment, specifically that in condition number 4, that the date April 17th be replaced with the date November 1st.
Second.
Thank you very much. Moved by Mr. Owen and seconded by Ms. Malice that we grant the subject use permit in case V-11454-19-UP1. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
All opposed? The ayes have it, and the matter is granted. Congratulations and good luck.
We thank you very much.
Thank you. Please call the next case. Mr. Rissy?
Case number V-11455-19-EP-1 is a use request by Cindy and Asoldo Fume. The owners permit a separation of 4.5 feet to the wall, 3.5 feet to the eave of main building instead of 8 feet to the wall, 4 feet to the eave as required regarding a new one-story detached accessory building, garage in the R6 zoning district, premise known as 1608 North Bryant Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy?
Mr. Chairman,
Mr. Owen?
does staff have a copy of the language of the approved variance that was previously issued on this project?
Staff has copies of the minutes from the previous variance available for all the board members. I guess I should note for the record that this is case V-8342-97-1.
My next question is, can this use permit be issued despite the variance condition requiring a 7-foot setback? Would the use permit supersede the variance?
Yes, this use permit can be granted despite the variance. Again, we've mentioned a couple times this evening that staff's position is that the variance is tied to the property and the structure. In this case, both the deck and the garage that were a part of the variance application in 1997 are not applicable to this application. The deck has already been removed, and this application proposes to remove the garage. So that variance, in effect, is not.
The advertisement was for, oh, I see. Got it. So the variance, in effect, has no real force. It hasn't expired, as Mr. Melnick was concerned about with the previous one. It's just inapplicable. Is that right?
Agreed.
All right. Okay. Those are my questions for now.
Ms. Freshman?
Any comments from neighbors?
Yes.
Welcome. If there are no more questions, and it looks like the applicant's able to answer that one, Ms. Freshman.
Okay.
Let's move to the applicant, Mr. Fumi.
Actually, my name is Scott Friedman. I'm a landscape architect.
Okay, Mr.
representing the
Friedman,
community.
we'd ask at the conclusion of your presentation, you submit a speaker slip for us.
Oh,
Unless you, let me see if you're the agent. So if you would, at the conclusion, do that.
I will note that Scott is listed as the applicant's agent on the application.
Yes,
Umi, yes. Oh, it says owner's name.
bottom here.
As the agent.
Oh, yes, Scott Freeman, Land Stake Agent's name. Okay, go ahead. Thank you.
Thank you very much for having us. We do have neighbor approvals. Can I approach the bench with them?
Please, pass them straight up.
You can bring that to Mr. Rissy, and he can pass them to.
There are 2 pages to that. They're both stapled together. The first one lists signees, and the second one who was not present at the time.
We're just looking quickly to see exactly where these folk live.
16.
Anything else to add?
Well, as I mentioned, we're looking for the use permit to allow for the existing structure to be removed and rebuilt in a similar location.
Okay. Questions of the applicant? Hearing none, I'd be happy to entertain a motion then.
Mr. Chairman, I just, another question for staff. So I think you sent us an email about this general question of the 8-foot separation requirement and what it's for and what its background is. And I just thought I would ask that maybe we should put into the record what staff's current state of knowledge is with regard to why this is even a requirement in the zoning ordinance.
Okay, I did distribute to some of the board members some research that we did into how it came about to be that we have an 8-foot separation requirement between the accessory and main building structures. In short, it was a part of a series of changes to setback requirements that the county board approved on November 21st, 2000. It included a number of different changes. In addition to adding the new 8-foot required separation for certain accessory buildings that met certain criteria. Prior, it had been a 15-foot required yard. There was also at the same time a change in the policy that the yard was reviewed as a line parallel to the rear of the house, and so nothing could be within 15 feet of that yard. The change in policy was to be a direct measurement between the 2 structures. So those were primarily the changes that were made at that time. I do have a copy of that research if the board members would like to review it. In addition to that, the only thing that I would say is I have a copy of the minutes from the county board's November 21st, 2000 hearing where they made these changes. And the subject changes started on page 3, and in their motion, they said that be it ordained that to provide for adequate light, air, convenience of access, safety from fire, and other dangers to facilitate the creation of convenient and attractive harmonious community, and other reasons required that by the public necessity, convenience and general welfare, and good zoning practice, Section 32, which at the time what was being modified, subsection D of the zoning ordinance is amended, reenacted, recodified concerning the placement of 1- and 2-story dwellings and their accessory buildings and air conditioning units as follows. So as far as a why, that's the best I've got.
And not necessarily even specific to the 8-foot requirement.
No, this is all of the changes that were made at that time. And I can pass those minutes out if the board would like to see them.
50 feet to 25 feet. That was an effort to the center, from the center of the street it used to be, we used to measure from.
I don't know that that was made at this time. There were some modifications made to the centerline requirements in other zoning districts in this, but it might have been right around that time. I can pass out the minutes if you would like to see what was exactly changed back in 2000.
Thank you.
The specific changes do start on page 3 of that package that I gave you.
Yeah, they do modify that center of the road. That's in the
Section 32 by the coverage requirements for also.
air conditioning units. Okay. Further questions, Mr. Owen?
I have none.
Any further questions of the applicant? No, this matters with the board.
Mr. Chairman,
Ms. Freshman.
I move the Board of Zoning Appeals adopt the attached proposed resolution approving the use permit V-11511-19-UP1, subject to the conditions listed.
Thank you. It's been moved by Ms. Freshman, seconded by Ms. Malice that we approve the subject use permit in 1145519 UP1. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed? The ayes have it, the matter is granted. Congratulations, thank you. Please call the next case.
Case number V-11456-19-UP-1 is a use permit request by Karen Shea, the owner, to permit a setback of 24.5 feet to the wall, 18.5 feet to the porch, 17.5 feet to the porch eave instead of 25 feet to the wall, 21 feet to the porch, 19.5 feet to the porch eave as required from the 25th Street right-of-way, and to permit a side setback of 5.9 feet to the areaway instead of 6.9 feet as required from the right side property line regarding a new exterior cladding, second-story addition over existing walls with new front porch, areaway, and rear additions in the R10 zoning district, premise known as 3829 25th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rusi? Welcome, Ms. Shea.
My name is actually Jill Gilliand. I'm with Moore Architects. Karen Shea was called out of town on business.
Jill Gilliard.
Gilliand, yes, yes.
Gillian, architect, and yes. She's for Charles Moore, with Charles Moore.
Correct.
Anything to add?
No, we're pleased with the staff's report, but I'm happy to answer any questions.
Thank you very much. Any questions of Ms. Gillian? Hearing none, this matters with the board then too.
Mr. Chairman?
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached proposed resolution
Second.
Thank you. It's been moved by Ms. Malice, seconded by Ms. Freshman to approve the subject use permit. Any further questions, any further discussion? Hearing none, all in favor signify by saying aye.
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 All opposed? The ayes have it. Thank
Thank
you very
you.
much. Please call the next case.
Case number V-11457-19-UP-1 is a use permit request by Gabrielle Caruth, the owner, to permit a setback 5.5 feet to the wall from the left side lot line instead of 8 feet to the wall is required, and setback of 7 feet to the wall from the rear lot line instead of 25 feet is required regarding an existing accessory structure, outdoor fireplace, in the R10 zoning district premise known as 1401 22nd Street South. Staff recommends the board adopt the attached proposed resolution approving the use permit request with conditions.
Thank you very much. Questions?
Mr.
Ms. Malice?
Question for staff. Do you have an understanding of what the confusion was regarding permits?
Yes, there is sometimes confusion because there are structures that do not require a building permit that do require BZA approval to meet setbacks and coverage. And in this case, I believe that the applicant may have been told that she did not need a building permit and thought that she did therefore not need zoning approval as well.
So when you apply, so there was no visit to zoning at all, or to the county at all?
No, actually, the contractor and Ms. Caruth did go down and talk to the county, and we were told we did not need a permit. Then the zoning inspector, Mr. Rizzi, came out and left a notice. We met with him, and he took measurements.
That was Aaron.
Aaron, excuse me. I'm sorry, Aaron Sura. Excuse me. My apologies. Thank you, Gabby.
Sorry.
Yeah. It wasn't him. He was getting ready to jump on me. Rob Smith, and I have a agent. Yes, sir.
But Ms. Malice, I think.
I was asking Mr. Rizzi, the procedure generally is if there's no building permit required, the applicant doesn't go to the county to ask for one.
I mean, in this case, the applicant came down to the county and was told they did not need a building permit and thought that extended to everything.
And then built the...
And the permitting people wouldn't necessarily say, but you have to check with zoning.
Apparently not.
That's all I'm not arguing your case at all. I'm just...
But sometimes they do, actually.
Yeah.
But the
They're kind of glaring.
But that could have happened. You need to check with zoning, but it didn't happen.
Correct.
Any other questions of staff? Now, Mr. Smith, 1401 22nd Street South in Arlington, agent for the applicant. The applicant is here also.
Yes.
Yes, sir. Mr. Chairman, thank you for the opportunity. I appreciate the BZA giving us the opportunity to come and talk to this. And since it did come up, I will speak briefly on what our experience was. But I will say that Mr. Rizzi and Mr. Sura were both very accommodating and did a great job getting back to us when we did reach out to them. So we do appreciate that. Ma'am, to your point, Mr. Sura did come from zoning and also told us we did not need a permit. We even asked the question, should we stop continuing to build, and we were told no. And then after we were completed, then we learned that. So I think there was some confusion on multiple, and we certainly take responsibility that we should have known the rules, although they are a bit confusing when you try to read them. So we are here asking for forgiveness to some extent, ma'am.
No, I completely understand that lay people understanding zoning is not a requirement in the county.
Yeah, I will say that I feel like I know a lot more about it now, unfortunately. Mr. Rizzi did a great job educating me as we put the application in. I think our application, I hope you found it to be complete. We addressed all of the requirements for preponderance of the evidence and think that we showed that. We also have in our application letters of support from all of our neighbors that are living in all the 7 adjacent neighborhood lots. So we had a good opportunity to talk to all of our neighbors, show them what we were doing, and it was completed, so we took pictures and allowed them to come see, and you'll see those there. We also agree with the conditions that the county has and the professional staff has requested, so we stand here asking you for your approval of our use permit.
Thank you very much. Questions?
Mr. Chair?
Mr. Melnick?
So I noticed some of these, let's see. So I see that the applicable address is at the very top. Okay. So, so it turns out I don't have a question, because it looks like that's noted. That was my question, is the address of one of them, but, so I'm fine. If
22nd Street, but not 21st. Oh, I do. Now I do. Thank you.
It's kind of confusing the way they're numbered, sir.
I beg your
I
pardon?
said it's kind of confusing the way all the houses are numbered on the 21st and 22nd Street there.
And behind, obviously, and I just didn't see it until I skimmed through really quickly. Any questions of the agent or the applicant? If not, matters of the board. Ms. Freshman.
I move the Board of Zoning Appeals adopt the attached proposed resolution approving the use permit V-11457-19-UP1, subject to the conditions listed.
Second.
Thank you. It's been moved by Ms. Freshman, seconded by Mr. Owen to approve the subject use permit. Any additional comments? Ms. Malice?
You used the term agent.
Yes.
It's not a formal agent. I didn't see it.
No, not a formal agent.
I'm sorry. He just signed as the applicant's agent in the use permit form on the slip. Any further discussion? Hearing none, all in favor of the matter signify by saying aye.
Aye.
All opposed? The ayes have it, and the motion is granted.
Thank you very much.
Please call the next to last case.
Case number V-11458-19-UP-2 is a use permit request by Marianne Lavelle, the owner, to permit a rear yard setback of 19 feet, 18.5 feet to the eve regarding a new rear screen porch instead of 21 feet to the porch, 19.5 feet to the eve as required in the R6 zoning district premise known as 2642 North Quantico Street. Staff recommends the board adopt the attached proposed resolution approving the use permit request.
Thank you very much. Questions? Hearing none. Marianne Lavelle, welcome.
Thank you, and thank you for hearing my application. I hope you feel it's complete. I was happy with the staff report, and my neighbors are very supportive of this. It's the screen porch will take pretty much the same footprint as the deck that's there, a little bit larger, but it will replace an old deck.
Your neighborhood's gotten a lot of experience with use permits in the last year.
It has. Probably even more building permits as well.
Mr. Chair,
Mr. Melnick?
I'd like to make a motion.
I'd be happy to take one if there are no further questions of the applicant.
Okay. So in case V-1145819-UP2, I'd move that the Board of Zoning Appeals approve the use permit with the conditions as stated in the resolution in the staff report.
Thank you. It's been moved by Mr. Melnick and seconded by Ms. Malice that we adopt a motion approving the subject use permit. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed? The ayes have it. The matter is granted.
Thank you.
Very much. Please call the last case. Mr. Rusi?
Case number V-11459-19-UP-1 is a use permit request by George and Colleen Holzbach. The owner is to allow a separation of 4.7 feet between an existing detached garage and a new addition instead of 8 feet as required, and to permit a setback of 18 feet to the front to the porch instead of 21 feet from the North Oakland Street right-of-way regarding a two-story rear addition and front porch modifications in the R6 zoning district, premise known as 559 North Oakland Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy? Hearing none. John Hensley, right?
Yes, on behalf of the applicants, Colleen and George Holzbach.
Yes. Welcome. Thank you for coming, and welcome to the applicants. Anything to add?
Nothing. I'll just answer any questions you may have.
Thank you very much. Any questions of the applicant's architect?
I do have a question.
Yeah, a question of the applicant.
Or I'll ask you, and then you can decide who answers. I noticed we received at our desk a couple of some feedback from your neighbors and I noticed that, in fact, they didn't really say they were for or against. The wording was simply that they had reviewed the plan. Did I misread that?
No, you did not. That was the form that they were provided.
Okay. So could you talk about your neighbors' reactions to your plans?
I'll let Mr. Holzbach do that.
Yeah, I basically just gave everyone packets. I walked around and knocked on doors. No one answered the door, so I left them in mailboxes and with some instructions. But yeah, I'm rereading actually the form, the piece of paper I gave them to sign, and it does say, I guess it doesn't really say. I guess their signature is an agreement, is what I read. But I guess your point is it doesn't really allow their opinion, or
I just noticed the wording of it just said.
Yeah, I could have been off a little with the wording. I used a form from somewhere, I think, as an example. But
so can you tell us what their reaction was to your plan?
Yeah, the next door neighbor I know 551 really well. He was very supportive in person. We're really good friends.
What's his name?
That's Gabe Dunn. He's 551 North Oakland Street.
Letter we got. Okay.
And then the neighbor, let me pull out the map. The neighbor at 3710 she actually wrote me a very nice handwritten letter. We had a recent issue where 3714, those are renters with an owner that had put up a very large fence recently. So we were commiserating on that. We both weren't fans, but she was really nice and heartfelt and supportive. The neighbors, that was 3714 6th Road North.
And you were commiserating about a fence that 3710 put up?
I'm sorry, I got that backwards. She's at 3710 6th Road North. The fence property is a tent. Tenants live there. There's an owner that's not there. That's 3714.
Okay. What is her name at 3710?
I don't know her as well. I'd have to look at the letter, actually. I have that back here on the bench. Do you want me to get it? I can get it.
We don't have that, do we?
Yeah, we do.
I think there was some confusion with, I submitted some letters later, and I think some of the letters that were, for example, this.
It's here.
Okay.
Teresa Stark.
Yes.
Okay.
Yep. So I had an in-person conversation with her, and then across the street, which probably it's not a contiguous property, but I know I talked to them after they gave me the letter. They were very supportive as well. The rest of the properties, I would add, actually, it's 3700 6th Road North. We have a happy hour for the street that he attends, and he had told me later in person that he was very supportive. So, yeah. Again, he's not contiguous, but the only person I did hear back from that was contiguous was 3706. Like I said, I dropped the letter off in the mail slot, kind of went back about 2 weeks later to knock on the door, and still no response. I didn't have any contact information. But everyone I talked to in person, in addition to the letters, 3 people were pretty supportive.
That's helpful. Thank you.
Sure.
Any further questions of the applicant or his architect?
Here.
Mr. Melnick?
On make a motion on this?
I'd be happy to table it. Thank you.
Okay. In case V11459119 UP1, I'd move that the Arlington County Board of Zoning Appeals approve, grant the use permit as stated in the staff report with the conditions in the resolution.
Thank you very much. Is there a second?
Second.
Wow, harmony.
Yield.
Okay, Ms. Freshman seconded the motion. Any further discussion?
Mr. Chairman, I'll just note, this is another one of the 8-foot separation cases that leads us directly into the next item.
Hearing no further discussion, all in favor of the motion signify by saying aye.
Aye.
All opposed? The ayes have it, the matter is granted. Thank you very much.
Chairman Smith and board members.
Thank you so much.
Let's see here.
Mr. Chairman?
Go ahead, Ms. Malice.
We received it's actually for staff, we received a letter at our desk regarding a variance. There was no signature as to who sent it that I could find.
Complaint about 1718 North Cameron Street, BZA approval from July 15th, 2015.
It's a complaint.
Yeah, it says here zoning enforcement.
So, Mr. Rissy, do you know who sent this to us?
I may have a name on the return address of the envelope, but they didn't sign the letter, so at the hearing, this is all I have for you.
Okay.
I will check to see if we still have the envelope to see if the person of interest has identified themselves in the mail.
My guess is that the person who sent this was not trying to be anonymous. It sounds like they've, at least I hope not. But
It's interesting because
Is it recent? This is all 2015.
well, who is this signature on this back page?
I think that's evidence
yeah,
of what the applicant had
complained about.
averred to his neighbors that was
Was this that real thin lot? Up on the north side?
I'm sorry, I'm unfamiliar with the
By the
particulars
hospital.
of this case.
It's by the hospital, yeah. It's by the hospital.
Yeah.
I Googled
This
it.
was that lot that was vacant for a long, long, long time, and it went through several hands, and it was derelict, I believe. I think that's Tedeschi, yeah. I believe that's,
So for the record, we're talking about a letter we received regarding V-10985-15-UP-1 that was heard by the BZA. There's no action required from us, but I do wonder, does staff take action on it? Is this a
Has
complaint?
anybody gone out to look at it? Do we have any idea?
I'm unaware at this point, but they have addressed a letter to zoning enforcement, so I would say that,
It's 4 years ago.
yeah, I would say that they have made a letter to zoning enforcement, and zoning enforcement will follow up with the necessary and requisite actions.
Right. Okay.
But yes, this was an informational letter that was delivered to me, addressed to you, so I passed it along.
Got it.
well, and our call to action is to inform our future deliberations when we're deciding whether to approve the use permit for construction of exceedingly narrow structures on other non-conforming lots, which is what we do every case.
Yeah, Yeah, I'm not sure that,
It's, the follow-up, is the issue.
Right, exactly.
if we approve something and it was not built according to what was approved, or,
Here's recourse. Okay, now to our communication.
Mr. Chairman, I've read it and I have no objection to the letter.
Excellent.
Me too.
Peter, anything you want to add?
Mr.
I'm
Chairman,
sorry.
I
Go
just
ahead,
wanted
Ms.
to add, I think it would be of interest to urban forestry. Given that the board would
Yeah, we're asking about trees.
weigh in eventually, a copy to the chair of the Urban Forestry Commission, making them aware of our interests. They can follow up in whatever way they want with the county board.
Ms. Malice, do you think we should also copy the county arborist?
County arborist, did you say?
Yes.
I have no objection.
Is there still a county arborist? We still have that position, right?
I believe so, yes.
Okay.
Also, just due to this, the separation between buildings, just from a fire perspective, because that's what I thought, is that it was some,
That's one of them.
yeah, and so maybe the fire marshal of Arlington, if they wanted to weigh in about what's really too narrow, is there anything too narrow, just in thinking about between accessory buildings and main building.
Okay. So, Mr. Chairman, as we discussed at the last meeting, I think we're in a mode now where we're communicating with the county board. I neglected to reread the code section that I'm pretty sure I read a part of the code that says that specifically authorizes us to
Yes.
communicate
No, it
policy to
does.
the county
It
board.
does. I think it's an annual requirement, really.
Yep. And I think there's even something beyond the annual requirement, but I couldn't find it the last two times I reread the code. But I did a comprehensive read through the code a year ago when we were doing our general thing, and I remember coming across that and being surprised.
Yep.
But anyway, it sounds like the county board benefits from hearing from us about these recurring issues, that's part of the general scheme. That's why we have the annual report, and others is if there's recurring issues, the county board should be notified. These are two of them. I think there's others that we might do in the future. We were talking tonight about the deck replacement issue.
Yeah.
That might be one. But here's two to start. And so I would move that the Board of Zoning Appeals authorize the chair to send this letter to the county board on behalf of the BZA.
Second.
Any further discussion? All in favor?
Aye.
Aye.
Aye. All opposed? Ayes have it, and I'd be happy to sign it and make sure with the addition of those two,
Three.
2 or 3 CCs, yeah, additional CCs.
Mr. Chairman,
Ms. Freshman?
I move approval of the March 13th, 2019 BZA minutes.
Oh, thank you very much. Thank you all for the attention paid to these two. Is there a second?
Second.
Thank you. It's been moved by Ms. Freshman and seconded by Ms. Malice to approve the minutes. Any further discussion? All in favor signify by saying aye.
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 All opposed? The ayes have it.
What about the dates?
Oh, yeah,
Thank
dates.
you.
Thank you.
Almost got away.
And also the full discussion, there were some questions asked. The code, the law doesn't say how many meetings we have to have or
Okay.
when we have to have them.
Okay.
So we don't have to have 11, we can have 10. We can take the month of August off if we want. Staff has some issues with that creating additional work, but, piling, but, we certainly have the power to really direct ourselves.
My point was only that we have two members now who seem to need to be gone most of August, and why not just acknowledge that? And not me.
vacation. So that's,
Civic associations and, go sort of silent and, so there's a lot of reason to do it.
so is there any reason that we could not meet this August and make a decision about future Augusts? Do we have to have a consistent pattern year to year?
No, they were not required to do that either.
That's kind of a convenience, but
If we don't meet in August, this August, we've become a new pattern.
That's true.
So next January, we can look at skipping August. And meet in January for a business meeting if we think that works.
I would, I think there may be some, I know, I'm talking about this. There's some issue, some folk might be put off by delaying this year, but I think that, it does serve people too who do take vacations, like,
There's county staff that are not here.
county staff, architects and planners and
And the like, so, and you're right. Next year, it's another group of folks.
So I would say, I'm all other things being equal, I weigh in favor of not meeting in August. But for this experiment, I'll be interested to see how that impacts September.
Yeah.
I think and July, because I think we're going to be under more pressure than usual in June and July. So the June ones that we would normally defer to August, we're going to say June goes all the way to September,
Right.
and there's going to be more whining and complaining from those people, right? And then also September, and there might be a rush to get in for July with not very well baked applications, right? And then September could be heavy. And I'm actually up for all that, but I would just say, I hope we can all appreciate at the staff and board level that we might make other little adjustments, whether it's, the good news is that the now planned July meeting is at the very end of July.
Are we definitely moving that? We haven't done that.
Yeah, well, let's look at
Well, we
this
should
here.
do it.
Let me look at my calendar.
Yeah, because I'll be back. I can actually do the 24th.
But we had 5 people on the 24th.
I certainly agree that even when we have 4, we're cutting it close just because anything could happen
Right.
to any one of us any given day. But when you know that.
I think it's helpful just for me because it's hard, I do all my prep work on weekends for the BZA, and so if it may be possible to have a package of a tranche of applications that come earlier than the Friday before the meeting in September, so that if we have 21 applications in September, that maybe we could see the reports for them an extra week or 2 in advance to help us prepare, ask questions, get them more in ship shape. Maybe that would be helpful to us and the applicants. And then we'll see.
That also makes sense for the February meeting, too.
Yeah. And so, just something to consider. And maybe it'll be fine. Maybe we'll just roll into September and it'll be a slightly longer meeting, but it will still finish by 11, and that'll be that, and we'll say it's great that we didn't meet in August.
Okay, so we're moving July to the 24th, and we're not doing August, correct?
We are moving to the 24th? Just checking.
That'd be my recommendation.
Okay.
we'll make a resolution.
I think the law requires us to do a resolution.
Well, we didn't adopt a calendar beyond June, I believe.
Good. That's what we'll do. So July, we're moving to the 24th.
Otherwise, and then so what did we approve through June, or, yes?
Yes.
Okay, so we need to do July, September, October, November, December.
July, staying with the Wednesday dates.
July 24th.
From the 17th to the
Whatever
24th.
you've already published given us for September through December.
Yep.
I think that wasn't controversial.
They weren't at issue.
So August is a bye. All right. Let's see here. Okay. September 18.
Okay.
October 16, National Bosses Day. Glad it's early in December. That's good planning.
November 11. Okay.
Okay, having heard the new dates, all in favor of adopting this July through December calendar. July 24, August 14, August is eliminated. September 18, October 16, November 13, and December 11 of 2019. Is there a
Motion?
Okay, it's been moved by Ms. Freshman, seconded by Ms. Malice. All in favor signify by saying aye. Aye. All opposed. The ayes have it, and our new calendar has been adopted. Oh, yeah, that's, I mean, we don't, that isn't something that we can resolve to, you can't order them, but the earlier the better. For specifically those 2 months, given that the likelihood that they'll be heavier, if the February and the September reports can be issued as early as possible, that would be helpful. It's been moved by Ms. Freshman and seconded by Ms. Malice to adjourn at whatever time it is. All in favor, signify by saying aye.
Aye.